29 cases, retokens of 2016. So the last occasion on 3rd December, it was listed. Appellant to time, and your lordship directed to list it of 7th of January. It could not be listed because of it was on the question of maintenance only.
Pardon to mention, my lord, land acquisition matter. The bank was before your lordship that the land acquisition officer had partly given the compensation, partly had held up in favor of the bank. The matter has been settled, my lord. I pray, my lord, I filed a miscase for withdrawal recording that. Ship may kindly record it for us.
Yes, Anderson, land acquisition.
Pardon for making message, my lord. My lord, item number 39 and 40. Here, interim stay granted by this honorable court. My lord may kindly abstain and take up this matter any after 20th, my lord. My lord, I am after 12th. I am not available here because my train is.
No, compulsory retirement of a judicial employee, 2020. After notification.
Yes. No, this is letter against the order of the case, but the land outlay has been directed to the employer by the narco. Narco has challenged that order.
One criminal appeal bail application, my lord, petitioner is inside custody since more than 10 years.
Pardon, my lord. One WPC number 64 of 2025. I filed a petition before this court under OGLS Act. My lord, here interim stay I pray for. My lord, may kindly take up this matter on 13th or 15th, my lord, specifically.
You cannot say on what date we'll take up the matter. Don't make such type of mention. We'll see our list, our convenience, how much case is posted on a particular day. Then we'll post the case. Don't say that let it be listed on 13th. Yes.
Pardon to make a mention, Your Lordship. This is a case filed against the EPFO. The recovery proceedings has been initiated. That's why the urgency hence. So, bless you, Lordship.
My lord, WPC number 4195 of 2016. Matter relates to section 13(8) of SCI.
Supplementary list. Item number 1.
Item 1.
Item number 1. Similar matter has already been settled by the arbitration and given the High Court to fix the matter on 15 January.
15 January.
15 January.
My lord, it relies on the judgment of Narottam Ratha of this honorable court, which was challenged before the honorable apex court, and honorable apex court has demanded the matter back and fixed a date fixing certain issues to be decided. But then, my lord, it has to be decided by your lordship.
On case-to-case basis.
Yes, my lord. Case-to-case basis.
So just give those list if you have got other cases also.
I think in government has proceeded
Yes.
against the order.
Yes, sir.
So number of cases have been taken up in that.
All those cases.
Just give the
You
list.
give the list.
And the order copy I have also.
Where is that order?
Madam, that is there.
Oh.
Series of cases. Series of cases. That is series of cases. Yes.
That is it now. So it's separately expeditious to all rights on.
Yes, pass the provision the kind of
The land counsel for the petitioner produced the order passed by the Honorable Supreme Court dated so and so in so and so case number 10. Copy of which has also been handed over to the land council for the state to seek some time to go through the order and file a memo indicating the cases which are to be listed in terms of the order of this court. So all these cases are to be definitely just give the application number that is there also in that.
Yes.
Okay, so that it can be file the memo, try it tomorrow, so that he wants it next week, it can be tagged together in view of such submission. This matter be listed. Let it come on week commencing from 28th. In the meantime, you file and ask the postmaster so that it can be tagged. बुझले ना? So the lead to देवे, सेटा को tag off कर.
Item 2.
Item 2, my lord is directed, last occasion, my lord directed to produce the rules. Today, we are filing the affidavit with rules. We have a rules, what my non-friend submitted, we don't have a rules, we have a rules. That rule was submitted here with, if one password, I'm just coming, my lord, one pass, I'm coming. We'll serve the copy to my non-friend today also. If you take time, then otherwise, I'll come and one password, I'll come any other.
We are solving the copy today. You will also kindly keep this matter to tomorrow so that let me to go through the what affidavit they are filing.
Let them, first of all, let them produce the rules. Let a copy be served, because on this ground itself, the case has suffered number of adjournments. We do not
Yes,
want
yes,
to adjourn again
Today-
by passing similar order.
Okay.
Mr. Pari has stated that he will make one passover. We are
Only
making-
one password, I'm just coming. Yes.
Item 3.
And last to the order dated 26/11/2024.
Please place that order, Mr. Guru. Why are you not using that, please?
I have got this in out.
No, that's all right, but we have kept it for your use, not that use. Order dated 26/11/2023.
The petitioner confirms that
Yes.
consultants of the defendant Swiss Matwali has filed a requisition with prayer for a direction to the particular review of the balance under Comfort Town Union number 4 Goldberg under the OJL side. Ballet Township of the petition submitted that the petition paper OJL mistake number Patel side before the Tahsildar Sarkar Sambalpur, OP number 3 under section 4 of the OJL side with a prayer for settling the schedule A permanently in his favor for issuance of RO. However, in the meantime, 21 years have passed, but no final decision has been taken in this case. It appears that the Lion Council for the petitioner will enhance the order sheet of the said business up to 28/20/2004. Lion Council for the petitioner will try to obtain the entire order sheet of the said miscase. Here I have already taken the black sale.
Black sale.
Black sale.
What is the, no,
Last order my lord passed in the 2023.
2023, last order.
Last order.
very good.
Page number 4.
Page number 4, it is 21, either 8 or something of 2022.
2022. Thereafter, no order.
This is 22.
This is the last order.
This is the last order.
This case is taken up, here is the case record, order document, ask the concerned RI to conduct an inquiry and submit the status of the case land and other related information relating to this. In 3 days.
The RI already submitted the report, that is also thereafter.
No, you mean to say that thereafter no order?
No order passed.
So what it means was additional Tahsildar. The matter of the year 2003 and in after 21 years
This additional document मैं learned senior में serve me a copy. I'll take instruction next week. Lordship में fix it.
we are asking you to submit a report
Yes,
as to why there is delay in disposal of this.
my lords, my lords.
To not dispose of a miscase for more than 20 years. And what your additional tahsildar is doing there?
My learned senior may serve this
Yes,
copy
the
of this.
That flag 10 you have.
I'll submit.
Right, in pursuance of the order dated 26/11/2024, the Learned Counsel for the petitioner has produced the order sheet of
In this case,
in miscase no miscase number OGLS miscase number 29 of 2003, and on perusal of the same, it indicates that on 28 and on 21 এটা কিন্তু 21/8 না কিন্তু এটা
6,
21/6/2022 additional Tahsildar Sadar Sambalpur, after perusing the case record and attached document, asks the revenue inspector to conduct an inquiry and to submit the status of the case land and other related information relating to the case within 3 days. The Learned Counsel for the petitioner submits that in pursuance of such order, the revenue inspector has not only conducted the inquiry, but has also submitted the report, and that the same has also been annexed to the memo. He submits that in spite of receipt of the inquiry report from the revenue inspector, there is no further progress. Stopped. And no further order has also been passed in that case. This miscase was instituted in the year 2003, and more than 21 years have passed, but final decision is yet to be taken, which is a very sorry state of affair. Let a report be called for. Who is the collector of that district?
Sambalpur.
Let a report be called for from the collector Sambalpur. So also the additional Tahsildar Sadar Sambalpur as to why there is inordinate delay in disposal of OGLS miscase number 29 of 2003. Report to be produced before this court by the Learned Counsel for the state on the next date, which is fixed to 21st of January 2025. Free copy of the order be handed over to the Learned Counsel for the state for compliance.
Item 4.
This will be appearing for the opposite party number 4 and 5.
3 to 5.
3 to 5.
I'll subtract the copy, SLP copy, and it has been renumbered as SLP number 344 of 2025.
No, just come to that order which we passed, a detailed order and passed when 12. Is it available there?
Yes, sir.
Please place that order.
The matter is taken up to hybrid arrangement. Lord Counsel for the opposite party number 3 to 5 has filed an affidavit in court today, which is taken on record. That a copy of the affidavit be sought on the Lord Counsel for the petitioner, so also Lord Counsel for the state. The petitioner, Himbat, has filed the petition seeking for a direction to the opposite party number 3 and 4, release the compensation amount in terms of the order dated 13/1/2022 under Annexure 1, order dated 6/1/2023 under Annexure 6, and the letter dated 4/6/2024. Yes, ma'am. And 28/2024, and the proceeding dated 27/2024 under Annexure 7 series within a stipulated period with a further direction to the opposite party number 1 and 2 pay the compensation to the petitioner as per order under Annexure 6 and 7 series with interest in recovery same from party number 3 and 4. It appears that the opposite party number 5 earlier approached this honorable court in WPC number 27355 of 02, and this court by order dated 22/11/2022 disposed of the same, directing the opposite party number 4, Department of Energy, Government of Odisha, to consider the representation filed by the petitioners in the said case and pass appropriate order in accordance with law within a period of 4 weeks from the date of production of certified copy of this order. In pursuance to the order passed by this court, it appears that the Government of Odisha Energy Department, by order dated 16/1/2022, found that there is no illegality or impropriety in the order passed by the Collector of Balangir, opposite party number 2, and accordingly directed the CEO, TPWDL, to take steps to purchase or acquire the land in the name of the Department of Energy, Government of Odisha, from rightful recorded owner of the land with necessary approval from all concerned on payment of compensation as per the provisions laid down in the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement act 2013, and the payment towards such compensation shall be governed under the respective vesting order of the commission, that is OERC. It further appears that a committee was formed, which is called District Compensation Advisory Committee, in which the additional district,
are the members.
yes, ma'am.
Then,
Patnagar, then
In
were the
person,
members
sir.
in the committee, and accordingly the market value of the land was determined. In pursuance to such decision taken in the meeting, land acquisition officer collectorate Balangir by letter dated 29/8/2024, which is addressed to the superintending engineer TPWDL, Electrical Circle Balangir, requested to deposit 2% of the contingent amount for 2,09,462 in favor of the land acquisition officer, Collectorate Balangir, at the earliest through HCPI check. It is the contention of the Land Council for the petitioner that such amount has not been deposited, for which no progress could be made. After hearing the Land Council for the respective parties, we direct that the opposite party number 4 and 5 to make necessary deposit within a week. Now, after the order was passed by the collector, that was challenged by the TPW before this honorable court, and this honorable court directed the energy department to take a decision, ma'am.
in the last order we say,
16 months, yes.
no, on 2/1/2025.
Yes, 2/1/2025.
We said that the opposite party number 3 to 5 submitted that he will supply a copy of the SLP
Yes,
to the Land Council for the petitioners, so also the Land Council for the state, and shall file a copy for the same before the court, and the matter may be listed next week. So
SLP, copy of the SLP is.
I have supplied copy, and I have also, they have challenged this order, 10-12 order, they have challenged. We have challenged the entirety of, not that.
Including this.
Including this.
So when the matter is sub judice before the Honorable Supreme Court, it is still sub judice or decided in.
No, it is still sub. They have filed.
The number SLP number.
2312, they have filed.
Number.
Supplied the copy.
What is the number of?
344/2025.
What the 2025
No, the diary number was 24.
registered
After reopening,
removal of defect
Yes,
has been numbered as this one. So
the diary number is there.
On 2312, they have filed.
no, it's all right. Now the case is sub judice, so it would not be proper to adjudicate it would be. So you take also steps to appear there because Who has filed this case before?
PPWC.
They were a party in the district advisory committee.
All right, but
No,
it's a
yes.
ground that they say that
Yeah,
it
yeah.
is, they are users.
Well, the question is that the government state council before the collector submitted, they have donated that land to the department.
No, one thing is that in view of the filing of this particular document, we cannot proceed with this case at present. We have to wait, right? The learning council appearing for opposite party number 3 to 5.
Right.
While the SLP petition hearing number SLP C number 344 of 2025, which shows that the so and so এমানে হচ্ছেন যে এটি আছেন the opposite party number 3 to 4 3 to 5
3 to 5.
the opposite party number 3 to 5 have challenged. What order you have challenged? What is the prayer portion? Let us mention it one time.
The order of this honorable dated page 16,
Just the prayer portion.
page 16, 10, 12.
I've challenged the ex party. Order dated 10/12/2024 passed by this court in this writ petition, right?
In this case.
Okay, the document filed by the land council for the opposite party number 3 to 5 taken on record. This matter. We are listing it after 4 weeks, let us see. Both the parties shall apprise this court about the status of the case. Matter to be listed February 10th for the status of this SLP on the next day. Yes.
But after supplying copy to the petitioner,
You mentioned that this SLP copy has also been supplied to Mr. Das.
as well as state, I have a copy.
As well as you have also received, yes. So both have received this document. And it will come 10th February 2022.
I'm sorry to interrupt, my lord. Before rising, can it, because there are things records and you are.
When the count is there.
Is there. So 12:30 or 12
No, we say that once you hand over,
Huh.
he is now.
Then
Okay.
yes. Now
So you just go through it, will take up tomorrow, or you want next week? Tomorrow. The item number 2.
तेरा कॉपी दे दो
Mr. P.K. Pari, Deputy Solicitor General of India, and
lot of time will be this
produced the copy of national, that is
National Water Development Agency Contributory Provident Fund rules. Yes. This is the original copy of the code. The second copy. Next, sir.
Produced National Water Development Agency Contributory Provident Fund Rules 1982 with the affidavit which is taken on record. Copy of the same has also been served on the Land and Council for the petition to seek some time to go through the same. Matter will be listed tomorrow. Why did you make such a submission on the first day that no such rule is in.
Lord, Ishwar Lordship will hear this matter. Just now I
No.
can prove that this rule is not there. Just now I can prove.
ସେଟା ଆମେ ସୃଷ୍ଟି କଲେ ଆଗ
Again,
ହଉ ହେଲା ଠିକ କାଲି ଶୁଣିବା
there is no such rule.
Item 5.
ଯାହା ସହିକି ଆସିବ ସବୁ ଗୁଡାକ ହଁ connected.
Exactly. It's there in the restriction, page 14,
Item number 5. ଜିନିଷ ଗୁଡ଼ିକ ନ ମାନେ ଭିତରକୁ ଦେଖିଥିଲେ WPC Are you able to see it? And are you comfortable?
Yes, sir.
Please argue the matter.
Look, page 14 is my prayer.
Yes.
I prayed for quashing of the order dated 14/8/2024 Annexure A passed by the executing court and allow the petitioner to make the payment as per the calculation submitted by the petitioner in the court as per Annexure 7. Lord, Annexure 1 is the LMS case and the order of Annexure 1, the Lordship will find at page 31. We had taken the lands, we had computed the amount. They made a reference, section 18 reference in LA case.
No, this is just a calculation made.
So we have made similar orders in other cases.
In three types of cases have been
Yes.
Lordship has been dealt with. In 2 cases, the Lordship had remanded back the case to the court below to consider it. 2 cases where I had shown your Lordship that I have given them a letter to come and take the money. In those cases, your Lordship has issued notice and stayed. Here is a case, the case is disposed of. I had earlier approached your Lordship. The Lordship had remanded back the matter and asked me to file the calculation before the court. I filed the calculation and he has again passed the same order and disposed of. And so what the only thing, we will pay the amount. What he is doing is calculating interest upon interest.
Period of interest.
I'll show that how it is. If a Lordship sees the execution order, that is at page 62, the calculation, page 62, the calculation made by the executing court. And my calculation which is submitted is at page 57.
That is 9% after expiry of the period, no? And
No.
he has considered
We will pay 9% and 15%.
We have paid, right?
We are ready to pay, but what he is doing is, he is calculating the 15%, then he is deducting the amount which he had paid as per the direction of the court, then again he is calculating the 15% over that amount, whereas he has to calculate 15% on the excess amount awarded by the court. Now what he is doing is calculating 15% over and above 15% again.
Against the amount which has already been
He is
paid.
not calculating 15% of the excess amount awarded by the court. He is calculating the 15% on the excess
entire.
amount plus 15%. Then again 15%. If a Lordship sees for a moment, page 62. $80,000, your date of notification 87. Calculation with the executing court has made 80,000 per acre, that is 4.47 acres.
Your main ground seems to be paragraph number 18 at page number 14 of the retribution.
No.
Right.
And I have given the calculation in detail. I have explained that in para 10. I explained how the calculation is to be made. In paragraph 10, I have explained.
Please go see this. This petition has been filed by the general manager. I will have one of the coalfields. Brother Nagar, Suram. The prayer to pass the order dated 14/8 2024, passed by the Learned Senior Civil Judge Jharsuguda in execution petition number 14/129-2002-2004. And directing the Chief General Manager, Ivy Valeria, Anadi Coalfield.
That order is at page 63. And the JDR number 2 is hereby directed.
Deposit and account fee check of rupees 34,23,655. That is in page number 63. Internal page is 6. Running page is 63. In favor of the decree holders before the court on or before 13/9/2024, positively, failing which the party would be liable, the petitioner would be liable, bracket like them with this judgment debtor 2 like them, would be liable to pay interest at the rate of 15% per annum upon 34,23,655 thereafter for the delay. It is the contention of the land council for the petitioner that the land executing court calculated interest at the rate of 15% upon the interest, but the court should have calculated interest at the rate of 15% on the excess compensation amount, that is 3,70,551.80. But the land court has calculated interest on rupees 8,80,000, which indicates one is the decree paragraph number 2. And therefore, this order passed by the so-and-so under Annexure 8 is not sustainable in the eye of law. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. You will appear for opposite party number 1. The land council for the state accepts notice for opposite party number 1. Extra copy of the writ petition is served on the land council for the state. So far as the two private parties, that is opposite party number 2 and 3, are concerned, repudiates for issuance of notice by so and so post shall be filed within 1 week. Matter will be listed 4 weeks thereafter. Counter affidavit if any be filed in the meantime. Yes.
I need for stay of these.
There shall be stay of operation of the order dated so and so until further order. Stay so.
Item 6.
Hot point for considered claims. The C is 1. He was leased out 1.5 acres of property. 2 purchasers. But so far as the 1 purchaser, the regional authority has said that OGLS is not applicable. Dismiss that order is part of this record. Now, so far as the other purchaser, the discriminatory order cancelling the original lease. So that will be my first round. If Lordship will see the
You are challenging Annexure 1.
Annexure 1 wherein the my vendor's lease is cancelled. My vendor was leased out 1.5 acres of property, out of which vendor has sold to 2 persons, each 750 days. So far as other vendee, Padmavati, a revision case was initiated for cancellation of lease. That was dismissed by the regional authority saying that the lease is on lease principles, OGLS Act is not applicable.
Yes.
So far as me is concerned, applying OGLS Act, my lease is cancelled. Initially it was cancelled. I approached this honorable court, that was set aside, remanded back. Then the regional authority reiterated the same order without applying anything, referring to the earlier. So this leads to a discrimination.
No, you come to the that operative part of that improved order at page number 18.
Right.
In view of the above, that last.
Kindly see page 18, para 4. In view of the above, ADM Bhubaneswar to the conclusion that lease granted in, but this is an earlier order which was set aside by this honorable. The same order is reiterated without any independent application of.
Just read that.
Right. In view of the above observation, ADM Bhubaneswar to the conclusion that lease granted in favor of office supports of legal infirmity, material irregularity of procedure, and therefore is set aside on 11/10/1974 of Tahsildar Bhubaneswar, setting an area of 1 and 5 out of Savik plot number so and so in favor of opinion with Tahsildar Bhubaneswar is directed to correct the records, take back the position of the lease and ensure its induction in the appropriate government khata. As a result, the as a result of lease land and to ensure its induction in the appropriate government khata, as a result, lease granted so and so is cancelled. In view of the above, I have the opinion that it should be recorded in the government khata. Now, this very lease, the self-same revisional authority has upheld, which has never been challenged, not set aside. How can you pass a contradictory order? Kindly similar, page 38. Page 38. This very 1.5 acres of property in favor of lessee.
No, what he says thereafter, just to read it out.
Right.
In view of the above, I am of the opinion to read out that.
Right. In view of the above, I am the opinion that inquiry report so and so is not found in WL case number 183774 143474. It has not been ascertained was the lease landless, no other profitable means of livelihood in his favor. Though the petitioner purchased the land subsequently and is on possession of the same, claim of the petitioners over the land cannot be accepted as the land was leasehold and lease was granted to the lessee under mistake of fact fraudulently and material irregularities in account of procedure. The revisional authority was right while passing the order dated 11/8/98 in the revision case 875 of 98, and the grounds taken by the present petitioner has no merit. Hence, the prayer of the petitioner is hereby rejected. Tahsildar Bhubaneswar directed to correct the error in favor of the government and revision case is disposed.
Yes, what is your submission?
Lord, my submission is this 875 of 98. Your Lordship will see one revision for the lessee, and that revision was dismissed by the revisional authority, Annexure 8, page 36. 27/11/2002.
The revisional authority was right in passing the order dated on page 11/8/98.
Right.
Yeah.
Kindly see page 36. Starts from page 36. So Lordship sees page 39. This was Radhu Behra and Padmavati Dei. Padmavati Dei is the other purchaser, Radhu Behra is the common lessee. See, Lord, kindly see page 39, operative part of the order. Since this is a case where question of salami was considered, it clearly indicates that lease was granted under lease principles. The said lease principles were repealed 84. As such, no action has been taken 783 of the OGLS Act, as lease was not granted under OGLS Act. Therefore, I do not feel it proper to interfere with the lease sanctioned by Tahsildar in WK 1837 of 77, which is the present reading. That's the lease case. The revision is disposed of so far as land in question relates to transfer opinion number 2 Padmavati Dei purchaser, plot number so and so 750.
No, last time when you approached this court,
Right, my lord.
that is in which is that order?
Right. That is an order, annexure, page 43, man. Page 43.
Annexure 10.
One second. That starts from page 41.
Page 40.
Sir is asking you his cancellation order, madam. Please try to understand. Annexure 9, page 40, man. This was the first order.
11/8/1998.
Correct, man.
Yeah.
This was the order initially passed against the lease. Lease granted 1837 is cancelled. Kindly see note page 42.
Page 42.
Right.
And result of the revision case.
Yes.
As a result, the lease granted in case
is cancelled. 1837 of 74 is cancelled. Am I clear, madam? Now this order was challenged before this honorable court. Page 43.
Yes. Then what happened? This court
set aside it, remanded back because I am the purchaser. I approached without giving me notice. The lease was cancelled.
So after that,
that first annexure 1. Meanwhile, for the other purchaser in 2002, they have upheld the lease.
Where is that?
That I placed it, man. That is the order, annexure 8.
Annexure 8.
Annexure 8, page 36.
The order of this court was passed in 2003.
Probably I'm not clear.
No, the order of this court in the WPC has been passed in 2003.
It was passed in 13/3/2003.
Three.
Yes.
And
yes.
after that, where is that order?
That is annexure 1.
Annexure 1, which
Yes.
is under challenge now.
Yes.
So after 2003, and that has been passed in
2020, August 2023.
24.
23rd of August 24. I'm sorry. 23rd August 24. Page 13.
Why so many years took it for disposal?
But they kept it pending.
No, in the same parlance, which order has been passed allowing that?
That is annexure 8.
Annexure 8. In 2000.
That is for the two purchaser. This is for Padmavati Vera. They have upheld the lease.
So what is your ground right now? How can there be a discrimination?
That's what.
But then you have challenged that order, and basing on that, this
This order was never challenged.
No, no.
Right one.
This is an order which is in your favor, in favor of other lease.
I have never challenged this order.
No, no. Which order dated 2002?
I have never challenged.
Why to challenge?
Yes.
It is in favor of another vendor.
Another, right.
All right. So you are one of the vendor.
I was one of the vendor.
Yes. And against you, the order has been passed.
Another order.
Another order has been passed.
Yes.
And the matter was challenged before this court in 2003.
Correct.
Basing on that, annexure 1 had been passed. So how at this stage you can say that there is a discrimination with regard to that?
I can say that it is discrimination because the lease case is 1, the revision case is 1. For one vendee, you are upholding the lease.
No. But has this been brought before that court while disposing annexure
Yes,
1?
yes.
So
Yes,
whether the court has met it or not?
No. Kindly see, man.
Let us see.
Kindly see page 19. They have not considered at all. Because this is the one revision case, my lord. Kindly see the number. Revision case is 1.
No, it's all right.
No, that is all right.
We just want to know from the state.
Right.
This annexure 8, which has gone against the state.
Because they say
Whether
that
it was challenged for this court.
yes. No, this one.
No, the one
Annexure 8, page 36.
Annexure 8, it is the state, it has gone against the state because Padmavati, in favor of Padmavati, the order has been passed.
Yes.
And that is the order you say that
Page 39.
the operating
As such,
portion
no
is-
action can be
Yes.
taken.
783 action has been
783 of OGL. This is what your lordship.
Yes,
Yes.
where the revision was dropped.
My lord's question is whether it has been challenged or not.
Yes, sir.
I'll have to verify.
Because he says that if the lease case is same and the revision case
Yes,
is
sir.
same,
There cannot be two styles.
there cannot be any
Yes, sir, I got it.
discrimination because in the case of that Padmavati,
Yes,
this
sir.
order has been passed. So we want to know that, and this was passed in 2002.
My,
And
2002.
Mr. Rotho says that this order was also brought to the notice of the authority which passed annexure 1, but he has not dealt with it. So region best known to him, he has not dealt with it. But just let us know that if whether it has been challenged it or not by the state.
Well, I'll take instruction. So the revision case, what is sourced from both the orders is the same.
Revision case is same.
Same.
That is no dispute about it. This revision lease case is 1, revision case is 1. So in that annexure 8, it appears that
In one revision case, 2 different types of orders. Annexure 8, whether has been challenged or not, I'll take it.
like, item number 6 months.
Mr. Rathore, one more clarification.
Yes.
In the writ petition which you preferred before this court, pursuant to the order of the revisional authority, which was again remanded, whether this revisional case 875 of 98 was also referred to.
That was the only case. That was the, your lordship is asking.
Then this has to be taken as, that is what I am telling.
No. It was not, because probably he might not be knowing. That specific factual aspect, not, no.
In that case, this order has to merge with, finally this order has to be merged.
No,
That
no.
cannot be taken as an order. Because in the self-same revision, you have preferred a writ petition and the matter has been heard afresh.
No,
So the
there are two orders, not kindly. There are two orders, not one.
one revision, as you said.
Revision one, but two orders. 98 order, 2002 order.
No, unless you have shown the discrimination to have been made by the self-same authority in the same revision before the writ court.
The earlier
How can you
petition,
take
I
the
was not a party there. In the past case, it was confined to the transferee only. Kindly see the order says. I was not a party there, nor I was noticed. I am not privy to that order. Because it was
No, you were not privy to that order. That is all right.
Right.
But it was within your knowledge or not? How could you?
No, I did not. I obviously not.
So how could you produce it subsequently before?
But only after the correction of ROR and all these steps taken place, he could realize.
But that order has been passed long since 2002.
2002.
And you have come, your order has been passed in 2024.
But no, it was 98. My order is fast. Mine was rejected fast.
But you preferred the writ only in 2003. By then, the other order has already been passed in 2002. That is what happened. Since the order was already before you.
Yes.
No,
it was not before me.
No, in the same revision.
It was not before me. It might be in the same revision. It might be lying in the order sheet. But I cannot know it. Unless I have noticed nor given an opportunity of hearing, I cannot know it.
The petitioner, Gangadhar Das, has filed this writ petition for setting aside the order dated 23/8/2024, passed by the Land Additional District Magistrate Bhubaneswar in revision case number 875 of 1998, which arises out of WLL case number 1837 of 1974 under annexure 1, with the further direction to the opposite party for a direction to the opposite party to correct the ROR in favor of the petitioner within a stipulated period, and further to quash the orders dated 24/6/2013 and 22/7/2013. These are the two orders, annexure 12 and 13, passed by the Assistant Settlement Officer Bhubaneswar and Additional Sub-Collector Bhubaneswar respectively. Stop. The Land Council for the petitioners submits that revision case number 875 of 1998 is a suo motu revision which was instituted under section 7A3 of the OGLS Act 1962 as amended from time to time in respect of the lease of acre zone 500 decimal of government land settled in WL case number 1834/75 for an area of acre 1.500 out of Savik plot number 647 under Savik Khata number 20 of village Patharagadia P.S. Chandaka in the erstwhile district of Puri, now Khurda, by the Tahsildar Bhubaneswar in favor of Radhu Behera, son of Sri Bhoguni Behera, of village Pathargadia. On the ground that it suffers from fraud, misrepresentation, material irregularity of procedure, and therefore it is not tenable in the eye of by order dated 11/8, that is at page number 40. Annexure. By order dated 11/8/1998, the ADM Khurda pronounced has been pleased to hold that the lease granted in favor of the opposite party, Radhu Behera, Radhu Behera, suffers from legal infirmity and material irregularity of procedure, and accordingly set aside the order dated 11 aforesaid order for them, aforesaid order dated 11/10/74. Accordingly, the order dated 11/10/74 of Tahsildar Bhubaneswar, settling an area of acre 1500 decimal out of Swanson of the letter. The matter was challenged before this court in WPC number 6966 of 2002 by one Gangadhar Das. How Gangadhar Das is?
He is the petitioner here. He is the petitioner.
Is the purchase, Bandi?
Purchase.
Is the Bhendi of this Radhu Das, na?
Right.
Right. So Radhu Behera, Bhendi of Radhu Behera, challenged the said order before this court in WPC number 6966 of 2002, which came to be disposed of by an order dated 13/3/2003. And this court not only set aside the said order, but passed by the ADM, but remanded the matter to the additional district magistrate Meshwar for fresh disposal in accordance with law after affording opportunity of hearing to the petitioner Gangadhar Das. The learned counsel for the petitioner argued that the impugned order would show that the additional district magistrate Bhubaneswar has mechanically passed the order, reiterating what has been held in the earlier order passed on 11/8/1998. And though it was brought to the notice of the ADM Bhubaneswar that in favor of one Padmavati Dei, the revision case was reopened on under section 783 of the OGLS Act on 10/6/2002 in the very said revision case number 875 of 1998, and the by the order dated 27/11/2002. The revision case was dropped as far as the land in question relates to the said Padmavati Dei, purchaser of plot number 1648/1964 acre 0.750 decimal is concerned. It is argued by Mr. Ratho, learned senior advocate, that when the lease case is won and revision case is won, the order passed in favor of the Padmavati Dei and the present petitioner Gangadhar Das should not have been different, and thereby the petitioner has been discriminated by passing the order under Annexure 1 mechanically. At this stage, the London Council for the state wants to obtain instruction as to whether the order passed by the London Additional District Magistrate Bhubaneswar in revision case number 875 of 1998 on 27/11/2002, in which Padmavati Dei was a party, was challenged before this court or before any other forum of law, and to apprise this court on the next day. Put up this matter in the week commencing from 20th of January 2025. Yes.
Grateful.
Item 7.
My lord, petition of challenging the inaction of the opposite party not providing jobs to the land outfit. Your representation is pending before the. Yes, my lord, pending. Which opposite party it is pending? Land acquisition officer. No, it has been addressed to General Manager. General Manager. Annexure 6. Opposite party number 2. Opposite party number 2. 2, my lord. Okay, so Annexure 6 is the representation. Authority is opposite party number 2 and dispose of in that time limit and communicates the order. Yes, disposed of.
Item 8.
I think item number 8 and 9 next week.
Humble request and another petition is to along with this
Please tell us the number.
30458 of 2024.
WPC number 30458
of 2024.
Any order has been passed in that case?
Similar matter losses.
No. I just
No.
whether it has been listed earlier, this 458.
No.
The London Council for the petitioner, 8 number elective, submits that WPC number 458 of 2024 is a similar matter.
30458.
Sorry, WPC number 30458 of 2024 is a similar matter. The matter we tagged to this case along with WPC number 30579 of 2024 listed 1 week after. Place this matter in the week commencing from 20th of January 2025 with item number 9, house 30458 of 1. Yes. Okay.
Item 10.
Hello, pending with option number 4, my lord. That is the representation made by the petitioners.
Annexure 3. Annexure 3 is pending before opposite party number 4.
My lord.
No, ये कौन जॉने लोगों को करती ना विभिन्न
The petitioners, several petitioners.
several petitioners individually करते हैं.
My lord.
Against opposite party number 4. Collector, district magistrate, Angul.
No.
अच्छा, representation होची annexure 3 reach ଆଉ pending ଅଛି opposite party number 4. 4, collector and district magistrate. है ना? On board, huh? That is to be disposed of. All right.
11 that is similar.
Huh?
11.
11 also same. See, annexure same.
My lord.
All right. Dispose.
Item 12. Item 13.
My lord, notification regarding acquisition of land issued in favor of the.
You are there?
Actually, my lord, let's say I have instructed to appear file, but practically he has not made any change party here. So any change in
No, yesterday he solved a copy on the Union of India. That was the direction. You have already solved.
My lord,
Okay. So where is the representation from the Union of India? Where is Mr. Padi or anybody? Is the player in this expedition?
my lord, the CMA by the Highway Authority, National Highways Ministry of Road and Transport, my lord, filed the case, my lord. And at that time, my lord, the one petition was filed by one of the co-sharer who are the defendants in the civil suit, said that there is one compromise between us, so the amount to be disbursed in favor of other co-sharers. And the land acquisition officer, my lord, allowed that prayer, my lord, in annexure 1, my lord. Only to state that, my lord. There is a civil suit pending.
Because of pending, the disbursement was not made because the pending of suit.
My lord.
In the observation annexure 1, the suit was dismissed on 24/2024. Thereafter, the award was disbursed in favor of the claimants, those who are by their official understanding. Next to this, when the suit was dismissed for default, the CMA is pending. There is no adjudication. Since there is no adjudication in the CMA or the suit has been dismissed, so the award has been though it is for their chance and the scope is there to challenge.
CMA this for restoration of this.
Restoration.
My lord, the restoration petition is filed, my lord.
And
also,
that is restored.
My lord, the suit was dismissed, my lord. At that time, my mother died, my lord. So the suit was dismissed, my lord. Against that order, I have filed to set aside the expiry order. My lord, that petition, that CMA is pending, my lord. I have filed also that I have annexed it, my lord. My lord, kindly see page 39, my lord. Page 39.
No, when the suit was dismissed.
Suit was dismissed.
Page 11.
My lord.
Page 11.
My lord.
Below para 1.
Just a minute. Page number 11. Page
annexure 1. Page 11.
Annexure 1 টা তো উচিত এটা।
Annexure 1 is order.
Annexure 1 series.
Improved order. See that observation ଅଛି ଖାଲି ସେ order ଟା ଦେଇ ନାହାନ୍ତି. There is an observation.
Who is this?
The computation part ଦିଆ ହେଇଛି ତା ତଳ ପାରାଟା.
Where is the
order of dismissal?
Order of dismissal. Have you not annexed it?
My lord, but I am filed, my lord. I have annexed, my lord, the CMA, my lord. I have annexed.
Where is that?
My lord.
CMA. Annexure 3.
My lord, my lord.
Have you mentioned
my lord, that is in.
I'll press power in favor of.
I have filed, my lord.
All right. This order passed on 25/9/2024. That is perhaps at page number 22. That shows that the suit has been, this CMA has been filed, and it was to set aside the dismissal order dated 24/6/24 and to restore the suit. That is the prayer, and it has been placed for office note. So in the meantime, more than 3 months have passed. So what is the present status of this CMA?
My lord, that is pending, my lord. That is for office note and city council.
If you will not take steps there,
no, my lord, we have already.
Then why will stay this?
My lord, this is, my lord, because, my lord.
No, you see, you instituted a suit.
My lord.
You did not appear. This suit was dismissed. then you filed a restoration application or for setting aside that order. Now, there also you are not taking steps.
My lord,
Then the
there.
latches are on your part.
Another
My
aspect
lord,
is
I am
there.
coming, my lord.
Another aspect, Lordship may can page 32.
I am coming, my
Here
lord.
there the person was approved of this honorable court.
My lord.
This honorable directed to the matter to be referred to the competent authority of 3HC.
My point
And
is,
on that basis, the matter is under annexed is still pending.
this is pending, my lord.
Suit is overriding the power.
This
Next
is
act
pending.
overriding the power. The special act is overriding the
My lord, when this is pending, my lord, the land acquisition officer has no power to say that to disburse the amount. My lord, that is, my lord, the suit for partition, my lord. Notice was issued in favor of other co-sharers, but my mother is the one of the co-sharer, and the notice was not issued, my lord.
All the co-sharers there in page 6 may
ଆପଣ ଯଦି ସବୁ ଯଦି
connect.
My lord, my mother is one of the co-sharer, my lord. My lord, the defendant number 20, my lord, is the another is the son of other sisters, my lord. He filed one petition, my lord. That is, my lord, in annexure in page 39, my lord. This is a false petition. No compromise petition was annexed, my lord. Only, my lord, stated that LA case 4/13 ମୁତାବକ ରାୟଙ୍କ ଭଗବାନ ଜେନା ଅନନ୍ତ ଚରଣ ଜେନା ଏବଂ ଅଭୟ ଜେନାଙ୍କ ଜଏଣ୍ଟ ଆକାଉଣ୍ଟକୁ ଜମି ଅଧିଗ୍ରହଣ ବାବଦରେ ସମ୍ପୂର୍ଣ୍ଣ କ୍ଷତିପୂରଣ ଦିଆଯାଉ।
No, one thing you just said.
My lord.
The order, improved order was passed on 5/8/2024.
My lord.
As it appears from Annexure 1.
My lord.
This suit was dismissed
My lord.
as it appears on 24/6/2024. So it cannot be said because your CMA was also not there. The CMA, the first order was passed on 25/9/2020. So as on the date of passing of the improved order under Annexure 1, there was no hurdle on the part of the authority to pass this order. That means there was no suit was pending by the.
At that time, the CMA also filed, my lord, that
You might have filed the CMA, but unless this is brought to the notice of the court.
My lord, that is, my lord, I said, my lord, without inquiry and without giving notice to us, if the LAO has passed this order, my lord, on the basis what? On the basis one of the co-sharers petition, my lord. There are more than 20 co-sharers, my lord.
So
My lord, kindly see.
No, why have you come at this stage? The disbursement is already made in favor of the co-sharers.
No, my lord. No, that is the.
That's it.
No, my lord.
Okay.
Nothing. ସେ ବର୍ତ୍ତମାନ ସୁଦ୍ଧା କିଛି ଦେଇନାହାନ୍ତି ଖାଲି ଅର୍ଡର ଯେହେତୁ ସେ ପାସ୍ କରିଛନ୍ତି
Just take instruction.
My
Yeah,
lord.
page 32 make a level. Page 32 make a level.
My lord.
The mother of the present petition approved the honorable court.
My lord.
Prior to institution of the suit. Then this honorable court directed the competent to refer the matter under TH National Act. PS4. Then matter is sub judice there for apportionment share. How can there be once suit is, the matter is pending before the competent authority for apportionment share? All the principal civil court, all the parties are there. The suit was filed, is that there is no meaning.
This civil suit was for what purpose?
Suit for petition, my lord. That is the joint family property, my lord. Suit is filed by my mother, my lord. In the meantime, mother dead, my lord. So we came to the picture, my lord. We have filed the setting aside expected decree, my lord. This is the case, my lord. There and at the same time, my lord, the case is pending, my lord. There is no disbursement, my lord. The case is pending, my lord. That is annexed here. That is annexed here.
Principal civil court as per NH Act. They are on sub judice the matter in session to apportion.
So are you remediless?
No,
Yes, my lord, because my lord, once they give the amount, my lord, to the
No, you make a prayer. You pursue your CMA. You are not pursuing your CMA.
No.
It is lying since October.
My lord, I am there.
What is the present status?
My lord, what?
Now it is 25.
The suit, my lord.
Yes, in CMA.
In the CMA, my lord, I will give the order sheet, my lord. My lord, because in every date, my lord, we have filed the Hajira and we
No,
are
no,
there,
no,
my
that is not the purpose of filing a hajra before the.
my lord.
Did you move to the court?
Yes,
The
my
matter
lord.
is fixed for office note. What are the
My-
defect or what is there?
My lord, in every date, my lord, we have filed the Hajira and moved before the court, my lord.
You produce
is
the
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 procedure,
latest,
my lord.
let us see, you produce
lord.
the latest order sheet
My
of
lord.
that CMA, number
Yes.
one. Number two is that you take instruction whether the disbursement has already been made or not in portions of the order dated.
Three years of pending, page 32 make a glance.
Page
3 years, I'm just NHAC
39.
page 32 रे order of this honorable court.
Yeah.
No, that is to be
नहीं,
taken by the
that
court.
apportionment is that is the jurisdiction. As
Yes,
per
that
the
is
LA Act, 70 is the reference. Here is the 3H power is there to
Yes,
apportionment a share among the co-shares.
My
They are
lord,
entailed as per their parties there.
This order was passed on 11/5/2023.
Yes.
But this particular order which is included here, it is on 5/8/2024.
That is the separate aspect. In that apportionment, NH Act, the award passed on NH Act prior to that. This CMA was under Annex 32 Principal Civil Court District Judge Jajpur is pending on the request of the mother of the present petitioner.
Yes, yes, that is what the order is.
Yes, the prayer is there, Mechanic page 37 Mechanic class. Prayer is there, deciding the dispute under the reference for apportionment of amount or any part thereof, any person to whom same, as good as is a civil court decree, it will be. The petitioner is not remediless. If the
That is what we are telling. You are not remediless. You can make an application, but you pursue your case.
my
The
lord,
CMA in a civil court, CMA is different.
my lord, when the suit is pending and also when this CMA is pending, my point is that the land acquisition officer has no power to say that the disperse to disperse the amount in favor of some of the co-sharers.
Alright,
Because my lord, kindly see the genealogy, my lord. Kindly see the genealogy, my lord.
This petition has been filed by the petitioners challenging the order dated 5/8/2024, passed by who has passed this order annexure 1.
Land acquisition officer.
Nothing has been mentioned here. This opposite party number
Or land acquisition officer, my lord.
3.
My lord.
Opposite
Opposite party number 3.
opposite party number 3, land acquisition officer, civil judge, wherein direction has been issued the accountant to make payment of the amount to the in the joint account of Bhagwan Jena, Ananta Kishore Jena, and Abhay Jena. Stop. The learning counsel for the petitioner submits that mother of the petitioner, petitioners, namely Annapurna Thor, filed a civil suit before the Civil Judge Senior Division Jajpur by the CS number 642 of 2022. The prayer was for partition.
My lord.
For partition. And the said suit was dismissed on 24/6/2024. Why it was dismissed?
That is dismissed for default.
For default.
As he was dead, my lord.
And to set aside the dismissal order dated 24/6/2022, the legal heirs of the aforesaid Annapurna Dhar died during the pendency of CS bracket level, who died during the pendency of CS number 642 of 2022. Filed the CML for restoration of the suit. And the order dated 25/9/2024 passed in the CMA. Number 79 of 2024 indicates that it was placed for office note on 25/10/2024. When we made a query to the Land and Council for the petitioner regarding the status of CMA number 79 of 2024, Land Council for the petitioner submits that there is no such progress in the CMA, and he will produce the order sheet, inter-order sheet on the next date. What time you require?
2 weeks.
2 weeks time. This matter on such answer. Yes.
Only till date, disbursement from now city.
You file a petition before the authority where the suit is pending.
Yes. Next.
Item number 14. May please alone. Because I was a process server in the court of ADJ2 in Bhubaneswar. The disciplinary proceeding was initiated against me, and I have been imposed with a major penalty. Because I am challenging the imposition of major penalty primarily on 3 grounds.
What is the allegation against you as a process server? What you have done?
But the allegation, the charge is at page 23, annexure 4.
Yes.
The allegation is primarily that I am not attending the residence office and that I am not coming to office on time. And in the evidence, there is also an allegation that I am not washing the car, which are not part of the duties of the process server under the rules.
It has not gone to the appeal.
You have not gone to the appeal committee.
With great respect, I bow down to your lordship's question. Well, here I will show to your lordships that the first show cause notice was issued in violation of.
No, you have not preferred your appeal before the appeal committee.
I will show to your lordships have held that if the show cause if there is a procedural
In
irregularity.
the appellate committee decision.
That can be decided by the
appellate committee decision.
Well, it's my great submission. My submission is that because the first show cause notice was predetermined and without jurisdiction.
Illegal,
whatever it may
whatever, everything.
Because that can be raised also before the appellate committee, and 3 judges of this court are the
Can you bypass the procedure?
This petition has been filed by the petitioner Panchanam Swine, challenging the order passed by the Land and District Judge Khurda, Bhubaneswar, on 2/1/2024 in DP number 1 of 2020 under annexure 9. Since there is a provision for appeal against the impugned order, the Land Council for the petitioner seeks permission of this court to withdraw the petition to oppose the appellate authority. Accordingly, the petition is disposed of. Yes, next.
Great.
Item 15.
Of course, the petitioner was earlier before your lordship. Presently, the impugned order is at page 75. Prior to that, if your lordship permit me, I can take your lordship to the earlier order passed by your lordship.
No, you are challenging the order dated 1/11/2024.
Yes, your lordship.
That is at page
75. Composite copy.
11, just a minute. 1/11/24.
Yes, sir.
Yes, please come to that order.
And this revision application was filed by the Tahsildar.
Just paste the first lines and then you go to the, we are just asking you that this this is a revision under section 7A of the OGLS Act, right?
Yes, sir. Yes, sir.
So it was instituted on the petition filed by the Tahsildar Sadar Sundargarh.
Yes, sir.
And why it was instituted and what order was finally passed in that order. So it was instituted for what purpose?
Challenging the order of the sub-collector, which has allowed my application. This revision has been filed.
Okay, Sub-Collector Sadar Sundargarh in Revenue Appeal number 36 of 2017.
My lord.
That order has, you have
Page 28.
Page 28, all right. Now, what this revisional authority or the collector did with the order of the sub-collector in the operative part of
Operative part, my lord, it says.
Come to that operative.
Yes, sir.
In view of the facts, page number 80.
Yes, Lord. I'm grateful, your lord. In view of the above facts, the opposite party found to be ineligible for settlement of the land under OGLS Act 62. Hence, the order dated 22/6/18 passed by the sub-collector Sundargarh, Revenue Appeal number 36/17 is set aside.
Okay, just prior to that, you see that why the collector has observed like that. That is in the very page. You read from the top of that page. That is further the opposite party has not questioned.
Not question the process of the land acquisition for which some portion, my lord, that has been wrongly typed.
All right.
Some portion of the leased area claimed to have been acquired for widening SH10. It provides that land acquisition has been done
by following
due procedure. Hence, there is no question of allotment of further government land against the acquisition of land. It is revealed from the submission of Tahsildar Sadar Sundargarh that certified copy of the order sheet of lease case number 200/16 filed by the London advocate for the opposite party, that the opposite party is not a landless person and she is resident of village Bhedabahal, having landed property in the said village. Further, at the present, opposite party is not in possession of the case land. As such, the prayer for the opposite party of the settlement case in her favor is devoid of merit. Fourth, the sub-collector Sadar Sundargarh High is order dated 26 June 18 in Revenue Appeal number 36/17 has directed settle the case land in favor of the opposite party with an observation that the opposite party has accrued the right of occupancy coupled with the right and title over the suit land.
So these are the two grounds, and other grounds you see, just the previous page 79. After being hard and going to the number one, come to number one.
79, my lord.
Yes, number one.
The learned advocate for the opposite party has stated that the opposite party has filed application to settle the case land measuring an area of 46 decimal before the Tahsildar Sadar Sundargarh and also claimed in different proceedings that land has already been settled in her favor recording the plot number 127/1185 in Hall Hour 97. Both the pleas are mutually destructive and contradicting her own stand. In this context, there is a clear discrepancy of the facts submitted by the non-advocate for the opposite party, as in one hand, he claimed that the case land was settled in favor of the opposite party by recording the plot number 127/1185 in the Hall Hour 97 by the Tahsildar Sundargarh, and on the other hand, she claimed that the opposite party again applied for mutation of the same land by mutation case number 712 of 2014 for recording of this same in her name. Second, as per the submission of the London advocate for opposite party, the copy of the form of granting lease of land for agriculture purpose produced by her. The opposite party has been allotted 5 acres of land, out of which she has gifted some portion of her to her relative, and some area has been acquired by government of Orissa widening of SH10. The argument of the London advocate for the opposite party is that in the above process, the leased area has been reduced less than 1 standard acre, that is acre 3.45, and hence the opposite party should be granted the case land on lease which she was illegally occupied. But here the court bill has said that having more than one standard acre, you are not entitled. But period of this fact, my lord, your lordship may also bear one thing in mind. That was the specific occasion for which your lordship has earlier entertained and directed the learned collector to reconsider giving due opportunity of the party. The basic fact is that the revision application has been admitted without notice and without serving a copy of the limitation application, having a delay of 3 years, 11 months, some days, my lord. That was the specific consideration. It was raised. Learned collector has taken note of that said fact. May I take your lordship to the, my lord, page 78?
Just a minute. The sub-collector's order was passed in revenue appeal on what date?
My lord, this was on 22/6/2018, my lord. 22/6/2018.
Have you annexed that order?
Yes, your lordship. Page 28.
Page 28.
Since it was not complied,
Just
pardon me.
So, your first contention is that this 22/6/2018 is the order which was the passed in appeal.
Right.
And in that case, the appeal was allowed and the order of the lower court was set aside and the Tahsildar was directed to settle the land in favor of the appellant. Appellant means the petitioner.
Petitioner, yes.
And this 2018 order was challenged in a revision petition before the collector, and that number has been mentioned. It is
Page
of
65.
2022.
Page 65, my lord.
Revision, page 65.
My lord. From the initial date, my lord.
65. That is on 2/6/2022.
My lord.
So, you mean to say that
on that day itself delay condoned without notice, my lord. First order, your lord.
Please show that order.
My lord, the very same page 65, I am reading, my lord. Peruse the petition filed by Tahsildar Sadar Sundargarh appearing through Sri Pradeep Kumar Mahapatra praying for revision of order dated 22/6/2018 arising out of Revenue Appeal 3617 of the Sub-Collector Sadar Sundargarh, which has been allowed. The petition of filed Wakalatnama and petition under Section 5 of Limitation Act on condoning delay. Third, I am convinced that there is sufficient ground to condone the delay. Delay is condoned, revision is admitted.
So, what is the time limit for filing the
90 days, my lord.
What is that?
7A, my lord, Section 7A of the OGLS Act, my lord.
collector may revise the order made by so and so. So, all right, thereafter notices were issued to you.
Notices issued. I have filed my preliminary objection raising or concerning the limitation as well as merit.
Okay.
But but the order was passed on 22nd 3rd 2024, and I approached this honorable court, and your lordship was pleased to remit the back, fixing the date to 2/9/2024 for the parties.
This 2022/3/2024 order you challenged in WPC number
that is at
27444.
no, my lord. That is at 18806.
Annex 10.
It start with
18806.
my lord. 59.
So, what order we passed that
Delay of almost 4 years in filing the review before the collectors from the order for ornament the deal. Everything. This completes the so far.
we set aside that order.
Yes, sir.
Then we remanded the matter for fresh consideration in accordance with that.
Fixing date 2/9 for the parties to appear in order to avoid delay, my lord.
Okay.
Thereafter, I have appeared that your lordship.
Where is that order? After this order was passed
my lord,
by us on 2.
That is 65 page. No,
65
is earlier.
Earlier.
Subsequent
20/8/2024 ପରେ
ଆଜ୍ଞା
ଆପଣଙ୍କ order sheet ରେ କ'ଣ order ହେଇଛି?
Pardon.
2/24 order ଟା ହେଇଛି. ସେଟା ଲେଖା ହେଇଛି.
Again, I have appeared on that day. That is at page 72.
Okay, so
97,
that means
my lord.
hearing both the parties, this order has been passed.
My lord.
Both the parties were heard and this order was passed.
My lord, my lord.
So, according to you, apart from the merits he has dealt it with. So,
he has only referred this point as per your lordship's order, but no finding whatsoever with regard to that.
What has been referred?
My lord, I am taking your lordship to the exact question, my lord.
Regarding justification of ground for referring it after the delay.
My lord.
No order has been passed.
No order has been passed.
You
page
have
78.
78.
My lord. From beginning, my lord, learned advocate for opposite party further about that after receiving the order passed 36/17, the Tahsildar Sadar Sundargarh filed this revision after a gap of more than 3 years, half year.
3.5 years.
That's
yes.
He was directed to work out the order of the appellate court by the honorable court. Well, these are the earlier order and content. It is not that it was not within their knowledge, because the appellate court's order was not complied or carried with. I approached this honorable. This honorable court said that since it is not challenged, you have to work out that it didn't do that. Thereafter, I filed contempt. In the contempt, they say that we are contemplating revision. This honorable court said that contemplating a revision will not stall the process. Accordingly, it was directed. Thereafter, this revision has been filed, and if your lordship will kind enough to have a glance over the limitation petition, that also I have annexed, my lord. Page 86.
No, that is there.
No, that is there. Has he not mentioned in this order that delay is condoned? That the 3 years
No,
period.
no,
say.
no.
Nowhere he has mentioned.
Nowhere.
Because that point was raised and.
Point
yes,
was raised, not answered. And I may also, my lord, admit my mistake.
Hmm.
Fairly, I admit, on that last occasion, I should have prayed that the condoning the delay order should also have been set aside. But the question in that event would have been that there is no revision. So that was my predicament, and it's a fact, my lord. But your lordship has specifically noted that such and such is the delay in act in accordance with law. He referred therefore, but thereafter not whispered a single word, my lord. And even after the direction by this honorable single bench, contempt, everything, they have not referred even their limitation petition, anything.
So whether it was not necessary on the part of the collector while passing this impugned order, since this ground was raised and this court has remanded the matter back to consider or at least say something that there is this, he has power to condone the delay. That is obviously there. But admittedly, it is more than 3 years delay because the order was passed in the appeal in 22/6/2018, and this was the first order which he has shown to us that was instituted in 2/6/2020. So his contention when he approached this court also is that I was not noticed. Admittedly, he has not been noticed at that point of time. So that is the reason why this matter was remanded back, and that means the while we set aside that thing, and it should have been considered whether the condonation of delay without hearing that party was not properly held. So on that aspect also there should have been determination. Have you is there anything to show that he has applied his mind?
Sir, in this case, my lord, that so far as my lordship is concerned,
No, we are not going to the merit because the first hurdle is that
so far as the limitation part is concerned, there is not never been any. But so far as the other aspect is concerned, my lord, the page 78, paragraph 4, paragraph 4 in the fifth line, that the on the basis of the claim has been made by the petitioner, the opposite party, I may read, my lord, the opposite party have submitted the said potta number such and such in the petition before the Honorable High Court as well as in the present revision case. This Tahsildar Sadar Sundargada argued or that the potta number such and such produced by the opposite party, which he claimed to have been issued on such and such, is a fraud document and the same has never been issued by the office of the Tahsildar Sadar Sundargada. Tahsildar Sadar Sundargada argued that we were not only trying to mislead the court, but also filing a search for the other. Next matter, the government leader Sundargada also.
All right, then we'll adjudicate this matter on merit also. Since he has passed the order, let us not go into that.
Let me we'll file the counter on that.
All right, this writ petition has been filed challenging the order dated 1/11/2024 passed by the collector from District Magistrate Sundargarh, opposite party number 2 in revenue revision case number 2 of 2022. The Learned Counsel for the petitioner submitted that the petitioner was the appellant in what is the case number of that appeal number?
Revenue appeal number 36 of 2017.
Revenue appeal number
36 of 2017.
36 of 2017.
17.
And the sub-collector Sadar Sundargarh had order dated 22/6/2018 allowed the appeal filed by the petitioner and set aside the order passed by the Tahsildar Sadar in Lease case number 200 of 2016.
Yes, hello.
And directed the Tahsildar Sadar Sundargarh to settle the land in favor of the petitioner. The Tahsildar Sadar Sundargarh preferred a revision before the collector Sundargarh on 2/6/2022 and with a petition for condonation of delay under section 5 of the Limitation Act and without issuing notice to the petitioner, the delay was condoned. On the same day, and on 22/3/2024, Collector Sundargarh set aside the order of the sub-collector Sadar Sundargarh passed in Revenue Appeal number 36 of 2017 and remanded back the matter to the sub-collector Sadar Sundargarh for re-adjudication and for passing a reason order considering the merits of the case. The aforesaid order dated 22/3/2024 passed by the Collector Sundargarh was challenged before this court in WPC number 18806 of 2024 and as per order dated 28/2024, this court has been pleased to set aside the order dated 22/3/2024 and remanded the matter to the Collector Sundargarh for fresh consideration in accordance with law and directed both the parties to appear before the collector. The learned counsel for the petitioner submitted that on the basis of such a remand order passed by this court on 28/2024, the collector has passed the impugned order dated 1/11/2024. But most peculiarly, while passing the impugned order, the collector has not condoned the delay considered the delay aspect, which was more than 3 years. And it is the further contention that the impugned order is otherwise not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Learned counsel for the state accept notice on behalf of all the opposite parties. Extra copies of the writ petition be served on the learned counsel for the state within this week. Matter will be listed after 4 weeks. Counter affidavit, if any, be filed in the meantime. Yes.
Yeah, yes.
IA number 16489 of 2024, there shall be stay of operation of the order dated 1/11/2024 passed in revision case number 2 of 2022 by the collector and district magistrate from the opposite party number until further order. Yes.
Grateful.
Item 16.
My lord, that is the Odisha government land settlement matter lots. Similar order may be passed in law.
Annexure 3, Annexure 4 to be disposed of by opposite party number 4.
सबुड़ा number ठीक है जी तो
आया
annexure number ठीक है
annexure का गोटे खाली for also
the two annexure 4
for खाली faster.
the faster with the annexure 4
अन्य गुड़ा
dispose of अन्य गुड़ा annexure 3
आया
to be generated. Yeah.
Item 17.
Registration order annexure 4 is pending before the OP2 matter. The case matter.
Representation is under annexure 4 pending before opposite party number 2 to be disposed of. Yes.
Item 18.
Yeah.
I have the order of the Central Administrative Tribunal. When a special allowance was directed to be paid by the Ministry of Finance by order dated. Thereafter, it was my pay was reduced and special allowance was withdrawn. Thereafter, special allowance was directed to be paid as it is excess allowance. And that notice and reduction of pay was the subject matter of challenge before the Central Administrative. You know, just have a glance what page 20 here. Annexure 1 page 20.
Now you come to the input order first.
Man.
Let us see what you what was your prayer before the London Central Administrative Tribunal.
Man. Prayer was there. Was the annexure?
Come to page number 47.
Page 47. My prayer was twofold. Firstly, annexure A by 7 and A by 10, and the applicant be paid with differential salary, which has been resulted out of the reduction pay by order dated 19/6/2018, with interest with a stipulated period. And second, grant any other relief or reliefs the applicant are entitled to under the factors of this case.
So you are challenging the order dated 19/6/2024, wherein your pay structure has been reduced. And then the consequential order where in recovery of excess amount that has been ordered. Okay.
Well, straight to come to annexure 7, 19/6/2018. Straight to. You are looking. First, you are page 36, annexure 6. Page 36.
Page 36.
Page 36.
Yeah.
Well, what is order? 19/8/2017. Well, there is a column, a special allowance is there. Well, I got it 1, 2, 3, 4. Special allowance. 4329. It was by this order, it was directed to be paid with effect from first paragraph. Pay of Sri Makeup is refixed in the pay band 3, 15,600, 39,100 plus with effect from 29/7/2013. Well, I got it. But 29/7/2013 is the date when I joined on deputation before the DIP as a registrar. So from the date of the joining, the order was passed. This special allowance is to be paid. Accordingly, this special allowance from that date was paid and that was deducted. Thereafter, your lordship, page 37, page 38, my lord, just like. This was after this order was passed 19/6/2018. Well, I am just reading the first paragraph. In pursuance to Central Audit Report for the financial year 2016-17 and 17-18 and period from 1/4/2016 31/3/2018 and subsequent order of Honorable Presiding Officer DRT Cuttack to implement the report of the Central Audit. The pay of the Shikam Makeup Assistant General Register DRT Cuttack is here refixed in the pay band 3 of rupees 15,000 so and subsequently as per matrix of 7th Central Pay Commission along with other allowances admissible under the rule.
Well, Your Lordship, in this order, the special allowance was deducted, Your Lordship, just as about the columns. No, so this order was the subject matter of challenge before the Central Administrative Tribunal.
Special allowance was withdrawn.
Was withdrawn. My Lord, this order, and I have been directed to pay that excess amount which I have received. And
Where is that line?
My Lord,
In this
Recovery.
very order, recovery.
my Lord, recovery order, Your Lordship, are either pays, my Lord, page 45 annex of 10. Page 45 annex of 10. Recovery of excess payment made against inspection report so and so payment of recovery of 4,23,471, that is 6,05,145 minus 181. 181 that is tax I have paid on the basic salary which has been revised. This is the inspection. This order along with this annex of 10 was the subject matter of challenge before this year.
But this recovery order has been passed long back in 19.
After that 22/1/2019.
No, is it in respect to the present, this one?
Well, after that order is withdrawn, 19/6/2018, Annex of 7. Annex of 7, you know, 19/6/2018.
Yes, Annex of 7 is of which date?
19/6/2018. Thereafter, this recovery order was passed.
Right.
And both these orders were the subject matter of challenge before the CAT. And it was initially stated. Thereafter, my lord, the CAT has decided what your lordship, my lord, what one line more. Annex of 7, when the Annex of 7 was passed by reduction of pay scale, I have submitted a representation before the authority.
Annex of 9.
My lord. Annex of 9. There I have prayed that I am entitled to get this special allowance because some other officers in the DRT are also getting the same. So we are entitled to special allowance are decided in the Annex of 3. Special allowance your lordship has been decided, my lord, just at a glance, there's 32 Annex of 4.
You are still continuing in there.
Well, I am retired now.
That is what. When did you retire?
Well,
when did you retire? After it, when did you retire? କେବେ retire କଲେ? But this order has been passed during your.
During my tenure as registered there. But the special allowance, your lordship, Annex of 4.
When this recovery order was passed, that there also you are on the before the tier.
I was continuing as the officer. During pendency of the proceeding before the CAT, I think. Yeah. Well, just at a glance, page 32, Annex of 4, where this special allowance comes, your lordship, this year. Page 32 minus salary revision for officers. Minus this is a joint meeting, conclusion of discussion between the IPA and other officers association. And straight we come to the page 34. The continuation of that meeting. What is decided? Page 34, paragraph 6, man. Special allowance. It was that with effect from 1/11/2012, officers shall be paid special allowance as ordered. Scale 1 to 3, 7. Well, this is the special.
What is the sanctity of this annexure 5?
Annexure 5 here.
This is a joint note between who are the signatories?
My lord. Annexure 4. My lord. Thereafter, annexure 5. Minister.
No, what is the sanctity of this annexure 4? It is just a joint note, not signed by any party. It is properly signed.
It has been properly
and
signed.
duly printed by the employees.
While all the employees and the officers all have signed.
All right.
Because the quantity is more.
Right.
My lord, thereafter, your lordship, well, it has been acted upon by passing the order subsequently 9/8/2007.
Right.
By including the special allowance in my favor.
So the annexure 5 has been acted upon in annexure 6.
Annexure 6. Annexure 4 has been acted upon in annexure 6.
Right.
And accordingly, I have drawn the salary.
Special allowance. At the rate of 4,000.
Annexure 7.
only basing on the audit report, Your Lordship. Because auditor is not the central audit. This is the
No,
question.
but is it withdrawn only in your case or with everyone? All those were.
It was withdrawn in all the cases. Some of the officers are succeeded, some of the officers are unsuccessful. Well, on the same issue, the Central Administrative Tribunal passed an order to quash that, Your Lordship. Same issue. Whether the special allowance. There are another judgment where my Lord Justice Sahu, before that judgment, it should be sitting in with my Lord Chief Justice, Your Lordship.
In this similar.
Whether my question in that case was that whether excess payment in favor of an employee can be recovered from his leave and benefits after his retirement, especially when it is palpable that excess payment was made by the authorities on an erroneous calculation or improper interpretation of rules and not because of any fault on the part of the employee.
That's a different.
Retirement,
I am happy. I am happy only on the point, Your Lordship, when the special allowance which has been withdrawn by me and it has been paid to me.
No, Mr. Patnai Rao, now you said that the Central Administrative Tribunal or have passed two different orders. One aligned and the other one declining. So where is those orders? Have you mentioned it in your writ petition? So what is the ground allowing it and rejecting it?
The learned tribunal was that, and while I'm just reading that last page 11 of that order, page 11, and I have it over there.
No, who is appearing? You are appearing. So how if this annexure 7 you have passed for recovery or you have withdrawn it and then you pass the order under annexure 10 for the recovery, how it can be said that it was mistakenly paid? You have passed an order that he is entitled to this special allowance, right? Then you subsequently said that no, you are not entitled to get. That's all right. But when you are passing the order, can it be said that it was mistakenly paid? It was by virtue of an order you pass that this is your pay and this is your special allowance. So as per the order, you have made the payment. So it has not been mistakenly paid. It was paid as per the order passed. So this Rafiq Masiya case that says that if it is mistakenly paid, then it can be recovered. Or it cannot be recovered after that retirement. That is the principle laid down there. So here, how if you by virtue of your order you have made the payment, how it can be said that it is mistakenly paid?
There are no misrepresentation from the side of the employees.
He has not done anything in misrepresentation. You passed the order. You decided that in view of the decided that we have to make you special allowance.
If at all you had no intention to pay, you could have dropped the allowance. But again, recovery.
I take instruction. For the first time, I'll take instruction.
So, like this writ petition has been filed by the petitioner Shrikant Kumar Mekar, challenging the order dated 2/7/2024 passed by the Central Administrative Tribunal Cuttack Bench Cuttack in way number 66 of 2019. The learned counsel for the petitioner submits that as per order dated 9 August 2017, the petitioner inter alia was ordered to pay the special allowance of rupees 4,329.93 per month with effect from 29/7/2013 while he was discharging his duty as assistant register DRT cutter. And on 19/6/2018, another order was passed by the authority in which that special allowance which was directed to be paid on as per order dated 9th August 2017 was withdrawn. Subsequently, on 22/1/2019, the order was passed by the presiding officer DRT Cutter for recovery of the excess payment that has been made on the heading of special allowance. The Land Council for the petitioner submitted that the orders of reduction of the pay structure of the applicant, so also the consequential order passed for recovery of excess amount were challenged by the petitioner before the Central Administrative Tribunal, and the Land and Trial Tribunal has been pleased to hold that the refixation of pay of the petitioner was as per rules, and recovery sought to be made was is also justified. It is the contention of the Land Council for the petitioner that as per the bipartite settlement, the special allowance was directed to be paid on 9th August 2017, but it was illegally withdrawn on 19/6/2018 order. Moreover, by making payment of special allowance as per order dated 9th August 2017, as per bipartite settlement, it cannot be said that such special allowance was paid to the petitioner mistakenly, and therefore, in view of the ratio laid down by the Honorable Supreme Court in the case of Pratik Machia versus so and so, the recovery order is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to the opposite party number 2. Land Council for the Union of India accepts notice on behalf of the opposite party number 1. Extra copy of the writ petition be served on the Land Council for the opposite party number 1. Matter be listed after 4 weeks. Counter affidavit, if any, be filed. In the meantime, interim application number so and so, there shall be stay of operation of the order passed by the Central Administrative Tribunal on dated 2/7/2024 in OA number 66 of 2009 until further orders.
Item 19.
Annexure to my representation is pending before opposite party number 5. My lord, I have filed intervention application, APC application, your lordship, that
And STR also submitted to the wrong authority, your lordship.
Prodigy, a grievance petition should have reached in the past.
And that grievance petition, he should have given to the collector according to the section 64, subsection 2, your lordship. And in this case, number of LRs are there, your lordship. In khata number, your lordship, in khata number 49, numbers of LRs are there. They have signed the payment register since April 2023. The land acquisition officer is not paying the compensation to them, your lordship. They are running before the land acquisition officer. In the meantime, he had filed receipt application with a prayer to refer the matter to Lara Court Sambalpur, your lordship. And in the meantime, the land acquisition officer had made payment to one branch of LR, your lordship, in 3rd January 2025, your lordship.
So we are disposing of this writ petition. You file the appropriate application before the appropriate authority. If this grievance petition would not yield any result, the Land and Council, he has filed the intervention application. Where is your intervention?
My lord, today I have filed, your lordship. My IN number is 495 of 2025.
There you have mentioned that who is the competent authority and what should be.
I have not mentioned because there is no need to refer the.
No, need or no, that can be also said by the authority before whom the grievance petition is filed. He can say that this petition representation I cannot adjudicate. He has to approach the opposite party. So if you give him a forum that this is the forum, so then it is all right. Otherwise, we'll just ask the authority to dispose of the representation. Let him say that he cannot.
Authority.
Yes. So this is pending before which authority?
Under land acquisition.
No, not he.
Opposite
Opposite party number 5. Annexure 2 is pending before the opposite party number 5. It shall dispose of. It is stated by Swansu that a intervention application has been filed. If the same answer has been registered or not?
Yes, lordship.
It has been registered as Swansu.
IN number 495 of 2025.
Let it on. In view of the order passed today, the said IA is also disposed of. Yes, next. Nata the equal.
Item 20.
Day before yesterday's matter, I was to examine whether the
Where?
Orera or Oriate, the scope of their adjudication, whether they can go to the genuineness of the documents or not. I have examined it, but that will be academic because it escaped my notice by virtue of section 58. Appeal lies to this court against the Oriate's order.
There is final order there.
So I will withdraw
Against this impugned order, appeal lies.
Yes, any
Let us see that.
section 58. Section 58.
Who page rachi boide?
So by the page 81.
80 81. 58.
Section 58.
Appeal to the High Court. Any person aggrieved by any decision of the
appellate tribunal may file an appeal to the High Court within a period of 60 days from the date of
all right. This writ petition has been filed by the petitioner Sambit Patnaik challenging the order dated 20/11/2024 passed by the so and so in so and so case. Appeal number Land Council for the petitioner submits that in view of section 58 of the Real Estate so and so Act 2016 appeal lies to this court, and therefore this is permission to withdraw this writ petition to prefer appeal. Accordingly, the writ petition is disposed of.
One more prayer, madam, that
Certified copy,
copy of the
certified copy of the impugned order be returned to the land council for the dictation on being substituted with so and so. Here.
Item 21.
May I please, Your printed given from the petitioner is claiming the interest of the land acquisition amount, ordered amount, that after 26 years of the land acquisition, the interest has not been paid, only compensation amount.
You have made the representation on 23/9/24.
Yes, very annexed report.
You have got no response from the other side. All right, before whom the representation is pending.
Yes.
Some civil judge senior judge Barampur allow the replacement that they are claiming that the interest part, that though the payment has delay, as because they are co-sharer of the.
Right, let him
Let
argue
not
that
co-sharer.
representation.
One stranger and
All right, annexure 4 is the representation. It is pending before the opposite party number 3. That is to be discussed.
Item 22.
Please, because this is covered issue, Millets. Your lordships are aware of the judgment of Ghanshyam Mishra Millets, which says that under insolvency and bankruptcy court, once the resolution plan is approved, all claims stand frozen, and whatever amount are claimed from the company after approval of the resolution plan, Millets, that cannot be enforced. Millets, if I may kindly take your lordships through the pages of the late petition, Millets. Plus the petitioner was admitted into insolvency on 26/7/2017. Let's kindly see page 26. Page 27, 26. This is the order of the Honorable NCLT, which at relevant page 31 minutes, this company Bhushan Power and Steel Limited was admitted into insolvency at para 9 bills at page 31. Page 31, para 9.
Yes.
As a sequel to this petition is admitted, and Mr. So-and-so, whose name also figures in the latest list of insolvency issued by is appointed as the interim resolution professional under the insolvency and bankruptcy code. Nonetheless, thereafter, the creditors were called and they filed their claims. The list of creditors I have annexed, that is at page 43. And this list runs into 1,778 creditors. They filed their claims, which ends at page 75. Around 1778 creditors filed their claims, including several government departments. The respondents here in they never filed their claims before the resolution professional. Nonetheless, the resolution plan the relevant extract is at page 76. This was approved. Your lordship, may I take your lordships to the approval order of the NCLT at page 82. May kindly see. See the order of NCLT delivered on 5/9/29. Annexure 5. Now we'll see this the operative part at page 215. The order is quite voluminous, and it if your lordship will take page 215. Now we'll see para 128.
Yeah.
As a sequel of the above discussion, CA number such and such is allowed, and the resolution plan of JSW H1 resolution plan applicant is accepted. The objections raised by the ex-directors, come promoters of the corporator, operational creditors are hereby overruled. However, the acceptance and approval of the resolution plan shall be subject to the following. Then will see clause D at the next page. The resolution plan,
clause D
at the next page. Resolution plan shall be binding on the corporate debtor, its creditors, guarantors, members, employees, and other stakeholders. The reduction of share capital, that is not relevant, but what has been done is the resolution plan has been made binding on everyone, including the creditors.
Plus, this order was then challenged and upheld by the Honorable NCLAT, the Appellate Tribunal. The order starts at page 220 before the Honorable NCLAT Delhi, New Delhi. And let's see page 321, the operative part.
321.
Page 321, para 148. Impugned judgment dated 5th September 2019 passed by the adjudicating authority, that is the NCLT. Approving the plan submitted by JSW Steel Limited is approved with aforesaid modification, clarification as made above. The order stay of implementation of the plan stands vacated. The approved plan be given effect immediately in the manner as ordered by the adjudicating authority and modified or clarified by this plan. So, 17 to 2020, NCLAT upholds the award resolution plan and also makes it effective. So there, plus then what happens, as your lordship knows, under the provisions of the IBC, the new management steps into the shoes of the previous management and starts on a clean slate doctrine. That is the judgment of Ghanshyam Mishra and also SR Steel. I'll show those judgments. They say that the new management, that is successful resolution appeal, starts on a clean slate without being faced with any undecided claims. Now, while things stood thus, I implemented the resolution plan. I have revived the company. I have restored the employment of thousands of employees. Now I am running the plant smoothly. Now we'll see what happens at page 323. The next page. Now we'll see 5/11/2024. This is regarding arrear demand of rent, cess, interest, and other dues for the financial year 24-25. With reference to the subject, it is to intimate that collection of land revenue of this office is very poor, so that the district magistrate and collector Sambalpur is pressing hard and given target for collection of revenue in all respect within November 2024. You are requested to deposit the arrear rent, cess, and other outstanding dues, if any, for financial year 24-25 before 30th November 2020. Well, we'll see the list of this demand and on the next page, which has been annexed. Now we'll see the outer extreme right column for which years? Financial year 13-14, 6-7 to 2021, financial year 13-14 and 13-14. These are all demands which are prior to me stepping into the shoes of this company. All these demands. Therefore, at page 325, I write them a letter explaining everything, including citing judgments of the Honorable Supreme. At 325.
Yeah.
Now, we'll see 1811. I reply to them. I refer to
325 is your letter.
Again, please. Yeah. Now, we'll see. I reply to them, explain everything relating to the IBC insolvency proceedings. I also cite the judgments. At page 328, I cite Ghanshyam Mishra judgment, which para 8, at page 328.
Yeah.
In Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company, the Supreme Court, Honorable Supreme Court, while deciding a batch of petitions on the issue of the legality of the claims of statutory authority or other authorities, including the central government, state government, or other local authority, which pertain to a period prior to the acquisition of a company under IBC, held categorically that the said dues and liabilities of the company would stand extinguished from the transfer date. The relevant para is reproduced below.
What is the transfer date?
As I showed to your lordships, 17 to 2020 was when
17
to 2020 was when the resolution plan was made effective.
17 to 2020.
Again. And these are all demands prior to that. Then will kindly see. Again, I clarify on 7th of March 2024 at page 330. And for whatever in fact, for subsequent years, whatever is the liability, I am keeping on paying. It's not that I have stopped paying. jaha thila subsequent years that I have been paying. At page 330, para 3 Millers will see.
Yeah.
Next page, I'm sorry, yes, 331.
Hmm.
Besides, we have already deposited a sum of 30 lakhs towards payment of rent and cess of government leasehold land of Lapanga such and such for the year 23-24. Details of which are stated below. So, Millers, what I am doing? Subsequent years, I am liable to pay. I am continuing paying. But these previous years, Millers are not at all my liability. And despite that, Millers, the impugned order, Millers, your lordship will see at page 366. I cited everything before. The judgments of Supreme Court, the judgments of this honorable court also. I have cited. In fact, there is another judgment, this honorable court. Multiple judgments also have come in the meanwhile of this honorable court. Your lordship will
your representation or whatever your objection, whatever you say, that is annexure 8.
Yes, Millers.
That has not been adjudicated.
They have not dealt with it, straight away said, no, you have to pay this demand. Your lordship will see at page 366.
No, they have taken note of that. Your reply dated so and so.
Yes,
because in the top of that
yes,
annexure 9 it is mentioned, but not dealt with.
I'm so obliged. That is what I am citing Supreme Court judgments. I am citing your lordship's judgment, this honorable court's judgments, and those are not dealt with, and I am faced with this demand. And now, Millers, if your lordship will call
Mr. Nayak, when you raised the demand and he had submitted a reply, a detailed reply has been submitted, including of course the Supreme Court decision. Then what is the purpose of them giving in this opportunity of filing this reply, and if you will not hear him, not deal with whatever he has stated, and just pass that you give this amount.
I have looked at that order, my lords, set aside this order, remand it back to the Sahasildar, let him consider all this.
This will be considered.
Very.
The writ petition has been filed by Bhushan Power, petitioner Bhushan Power and Steel Limited, challenging the order passed by the Tahsildar Bengali on dated 30/11/2024, in which the petitioner was asked to pay the arrear demand of rupees 53,23,823 as per the demand letter sent by later number 4995 dated 5/11/2024. It is the contention of the Land Council for the petitioner that when the demand notice under Annexure 7 was issued to the petitioner by the Tahsildar Bengali, a detailed reply was filed before the said authority as to how the petitioner is not entitled to pay any amount as per the said notice, and the decisions of the Honorable Supreme Court in the case of Ghanshyam Mishra and Sons Private Limited versus so and so reported in the reference study
2021 9 SCC 657
and Adhunik Metallics Limited versus State of Orissa reported in
2022 SCC online Odisha 4166.
Has also been
please check.
Just relied upon. But the authority, while passing the impugned order, has not considered the reply in its letter and spirit and mechanically directed the petitioner to pay the arrear demand as raised on 5/11/2024 as per Annexure 7. Without applying the mind, the contentions raised in the grounds taken in Annexure 8 stop. The London Council for the London Additional Government Advocate, Mr. Nayak, fairly submits that the order under Annexure 9 be set aside and the matter be remanded to the Tahsildar Rengali to consider the reply of the petitioner at Annexure 8 and give opportunity of hearing to the petitioner and pass a reason order as to whether the petitioner is liable to make any payment is liable to make any payment towards that area demand or not.
Prior to the resolution plan under Annexure 4. Prior to the resolution plan, Annexure 4.
Prior to the resolution plan. Accordingly, after hearing the Land Council so and so, the impugned order dated so and so is set aside. The matter is remanded back to Tahsildar Bengali. You will issue notice to the parties and after hear the matter and decide as to whether the contention raised by the petitioner that is not make any title to pay any demand, make any payment of area demand is sustainable or the same shall be adjudicated and copy of the order shall be communicated to the petitioner within 2 weeks of taking the decision. It's to be decided within 3 months of the date of receipt of the notice by the parties. Yes.
Taking into consideration Supreme Court.
Obviously the grounds taken in this one, so that will be considered personal hearing that is to be also accorded to and the matter is to be decided.
Obliged.
Already 15 years of mentioned convicted on the case of 3 or 2 million. Custody more than 10 years, 6 months.
Assignment, item number 34 is in the hearing. Appellant is in custody for about 18 years. I'm ready. Let's get ready. I did that, my lord.
There is a part heard criminal
ସେଟା ତ ଯୋଉ ଦିନ କରିବ ମୁଁ ପ୍ରାୟର ନୋଟିସଟା କହିଦଉଛି. So that will both will argue that.
Get ready so that particular item.
And, yes, because he's already custody for 18 years. On Monday, my lord.
Taken up next week.
Supplementary list, Item number 1.
মানে আই ফর মডিফিকেশন 3386 মানে actual ST number is 126 52 of 2009 কিন্তু ড্রাইভ করার মিস্টেক 125
Item 6.
Today I was served with a copy of the IA for bail, my lords. Here, my lords, it's a case where the direct eyewitnesses statements in there, and my lords, from the statement of the IO, it is mentioned that he has been arrested on 12/6/2007. But in the IA, my learned senior has reflected 29/8/2007. Let's, I may be given one opportunity to protect the
Initially, FIR was registered against the present appellant in an offence under section 341, 323, 325, 506. And basing upon that FIR, the present petitioner was arrested, my lord, 12/6/2007.
No, have you taken instruction? You come to that interim application.
Yes, my lords.
Paragraph number 8. Paragraph number 8 ରେ
Yes.
ସେ କହୁଛନ୍ତି ସିଏ 17 ବର୍ଷ 2 ମାସ ହେଲାଣି ରହିଲେଣି.
Yes.
So
That
what is the custody certificate?
custody certificate is not there. There is discrepancy in one date of arrest. So that is why I may.
Just obtain that custody
Yes, sir.
certificate,
Yes,
that
sir.
will do.
Yes.
Look on IA number so and so, this is an application for bail. In paragraph number 8, it is stated that the petitioner has remained in judicial custody for 17 years and 2 months in connection with this case. Let the land council for the state produce the custody certificate of this matter in the week commencing from 20th of January 2025. Yes.
Kindly in my kindly be reflected.
Mr. Akshay Kumar Sahu.
Regional representative.
Akshay Kumar Sahu लिखिए peruse the prisoner petitioner flag B. Mr. Akshay Kumar Sahu has in which prayer has been made to engage Mr. Akshay Sahu as his counsel. Prayer is accepted. Mr. Sahu has filed Vinama, that is also be accepted. तापर लिख देवे Mr. So submits that one. The name of Mrs. Soma Patnaik. This BKNI is your associate. Name of Mrs. Soma Patnaik shall not be reflected in the custody transfer. Yes.
Item 7.
You have, this is for the first time it is coming.
No, the second time, if you lucky director for supply for disposition procedural office, I have wrongly supplied the connected bill.
No, we have not asked you to supply. We have rather directed that
Yes,
you
sir.
can collect it
Copy,
from in your pen drive from the that because the trial court record is with us.
Yes, sir.
So
I have received from the office, but I have not supplied the technically wrong. Another connected appeal is there, if you are of same case, that case record I have supplied, separate trial.
And you have received the
No, the debt copy is not
on this.
no, why are you not? The order is very clear that in the pen drive you can collect it. The problem is that if you produce the pen drive tomorrow, there will be problem. So the
same day we can.
Yes, that is there. So yes.
Next week.
Don't say that he has not supplied you the pen. He's a jail criminal appeal. And yes, next.
Item 8.
The appellant custody since 2014. The IA for 12 months.
Now, my lord, he has filed a new application on account of death of his mother. I have filed it on 20th of the December. And it is custody from 26th January 2011. No, Mr. Jan, এই যে ground upon ନେଇଛନ୍ତି ଆପଣ ତ ଇଏ ବୋଧେ ସରିଯିବଣି। ଜାଗା 20 ଦିନ I am consider for some days taking into consideration my detention for about 14
No,
years.
that is,
You see, why are you not filing a fresh bail application? You are taking the ground of your mother's death. But on this ground, if you are released, it may be a little late. Yes, And particularly this my obsequious ceremony is over. We cannot. Madam may release me for a shorter period and taking into consideration my. You file a fresh one. That would be better. Because the obsequious period is already over since long. As you also 25 days ago. हाँ, obviously, हमारा बेटी maximum नहीं 13 दिन जाए चले तो हाँ, you file it during course of this week. File it. The IR number so and so. This is an application for interim bail on the ground that the mother of the petitioner has expired on 16. The land council for the petitioner submits that since the obsequious ceremony is already over, he does not want to press this application and will file a fresh interim application for interim bail. Accordingly, the IA is disposed of. Yes.
Item 10.
Custody in 8 years, 9 months, 1 day.
Well, I mean, senior supplied his custody certificate today only. That I have not verified that if your lordship considers it or lordship may.
Verify
Yes.
I have got this.
there is an order of this court that custody certificate ମାଗିଲେ
Yes.
ୟାଙ୍କୁ ମଧ୍ୟ ଦେଇଦବ ତେଣୁ ଆକୁ so is it the consideration for the first time? So you can face the matter also on merit, there is no problem because the first time we have to adjudicate whether he is entitled to bail on merit or not. Apart from this second, so is it a case under section? What is the offense here?
302 and 34 I think.
302.
There is no. LCR is fine. LCR is there. Actually,
Oh, the non-debt issue. The eguda can be a PW 1.2.
It's a judgment judge.
ଆସିଯାଇଛି ତ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ ଆସିଛି ଆସିନି ତ ଏଗୁଡା କେମିତି ଲେଖା ହେଲା ଅଛି ପୁରା ଇଣ୍ଡେକ୍ସ ସବୁ ଲେଖା ହେଇଛି ଆପଣ ଫାଇଲ କରିଥିଲେ କି ଡିପୋଜିସନ କପି?
No, I have received only this judgment copy.
देखिए ओरिजिनल रेट देखिए ट्रायल कोर्ट रेकॉर्ड ଆସିଛି আমরা কল ফর করছিলাম না 14/5/2024 রে ট্রায়াল কোর্ট রেকর্ড admit করি 14/5/2024 ରେ କଲ ଫର ହେଇଥିଲା ଆସିବ ନାଇଁ କଣ ସେଗୁଡା this is the trial court ମାନେ original ପଠାଉଛନ୍ତି ଜେରକ୍ସ ଦିଟା ସେଟ୍ ପଠାଉଛନ୍ତି ଯେହେତୁ ସେ division bench case ହେଲା so this noting is not proper so if both of you have got the deposition copies with you
No, I don't have.
then you please get it deposition copy you can argue on merit this is an additional thing the land counsel for the petitioner Suman Modi produced the custody certificate which is taken on record copy of the same has also been supplied to the land council for this case both the land council submits that they may be supplied with the deposition copies in their respective pen drives. Stoplet the registry, supply the deposition. The land council on their respective pen drives. Quite a bit listed on 20th of January 2025. आज यदि अच्छी पेन ड्राइव नहीं आ पुणी असुविधा हो जाए है ना
Till then he may be released. Till then he may be released on bail.
Please
Till then he may be released on bail.
no 21/1/2025 ରେ ଆପଣ matter ଆସିବ ଆପଣ if you are entitled to get the bail on merit then that is good thing you just argue it on merit because it has not been argued
No, it's not.
this is a thing which can be your bail application can be considered for a temporary period and this is applied when the matter is you are unsuccessful you can be released on interim bail for some period so you try your luck on that day on merit you have not gone through the deposition copy you do not know what is there so go through the deposition yes next
Okay.
Item 18,
yes Mr. Pradhan
In total 8 to 10
you speak in front of that mic the mic on ଅଛି ତ
in total 8 to 10 subjects examined. PW3 and 6 are the eyewitness. And PW1 and 2 are
PW3 and PW6
6 minors.
eyewitnesses what is the name of the deceased
Name of the deceased my lord Madhava Pradhan.
Date of occurrence?
Date of occurrence my lord 27/2/09.
27/2/09.
2009. 2009.
Who is the doctor who conducted PM?
My lord doctor conducted PM.
PW7.
PW4 minor.
4.
PW4 minor.
PW4 PM doctor.
My lord.
The PM is 4.
And the doctor who examined the
injured PW7.
PW7 doctor of injured. Who is the injured actually out of these two eyewitnesses?
PW3.
PW3 is the injured.
Sanatan Behar.
Okay. Now, the London court below, these are the eyewitnesses account. Apart from the eyewitnesses, is there anything like leading to discovery, anything like that?
No.
So only eyewitnesses.
Only eye.
Okay. So, how these two are related to each other, PW3 and PW6?
PW3 and 6 are father and son.
Who is the father?
PW3 is the father. PW6 is the son.
So, whether the deceased is related to this, any of these eyewitnesses?
No, co-village.
Co-village. So, what is the prosecution case?
So far as the FIR is concerned, my lord, যে 27/2/96 শুক্রবার সন্ধ্যা প্রায়
No, we have gone through the FIR. We want to know from you that what is the prosecution case?
The accused person suddenly came and assaulted deceased Madhav Pradhan by a wooden plank. As a result of which he fell down and thereafter medical and death.
Accused persons means there is only one accused. One accused.
Only.
So the deceased was assaulted on his head.
On his head.
By this appellant.
But
with a wooden plank.
Wooden plank.
Okay, that is the evidence of both the witnesses.
Both the.
Okay, the deceased died at the spot or died subsequently.
No, did he take any treatment or he was brought dead?
No, it is medical.
No. Did he was given some treatment?
No, my lord. Suddenly they taken to medical.
Immediately he was taken to medical. Was he given treatment?
There he was declared dead. And how the injured sustained injury? PW3.
PW3, my lord. PW3 was standing near the spot when he saw the accused assaulted him. He came to the spot and
assaulted him means?
Assaulted the accused.
Deceased.
Please be slow but speak correctly. How the question is how PW3 sustained injury? Speak in English.
When the accused person, when the appellant, my lord, then deceased Madhav was returning from the shop towards his village.
Don't read the deposition. We want from you,
my lord,
that you are to submit.
Suddenly accused Kirot Deoli came to the road
with a wooden plank, and at that time, the accused Kirot Devi assaulted Rishit Mathur. And the period one,
ଆପଣ ତାକୁ ଅନଉଛନ୍ତି କଣ? ଆପଣ କେସ୍ ଟା ମୁଣ୍ଡରେ ଅଛି ତ? ତ ଆପଣଙ୍କୁ ପ୍ରଶ୍ନ ପଚରାଗଲା ଓଡିଆରେ ଆଉ ଥରେ ପଚାରୁ PW3 କୋଉ ଭଳି ଭାବରେ ଆଘାତ ପ୍ରାପ୍ତ ହେଲା?
the appellant bite him and assaulted him.
No, circumstance kona. What was the circumstance that he sustained injury? Did he come to the rescue of the deceased?
When he tried to save him, at that time he assaulted.
Save him means himself.
No, save the deceased.
Tell in that way that first the deceased was assaulted. This man was there near the spot. He came to the rescue of the deceased and he was assaulted. Still like that, 2 to 3 lines. So now you have heard what she argued, that why the evidence of these 2 eyewitnesses should not be accepted. So how do you meet it? That was the question which was posed to you day before yesterday, right? That she has raised some points, and the first point she raised that from the evidence of PW3, it appears that many persons were there and they witnessed the occurrence, and only this father and son, they were examined, while others were not examined. So what is your submission to that? When let us say 5 to 6 persons were present at the spot, and you are examining 2 of them, you are not examining the rest 4. So what would be its effect? Whether the evidence of the other 2 witnesses were examined in court, that is to be disbelieved, discarded, merely because the other 4 witnesses have not been examined, even though they were present as per the prosecution case. What is your reply to that?
You would see the eyewitness, and he saw the incident, all the incidents, and he also tried to rescue him.
ଆଜ୍ଞା ଆମେ ପ୍ରଶ୍ନ କଣ ପଚାରୁଛୁ, ଆପଣ ଉତ୍ତର କଣ ଦେଉଛନ୍ତି? 6 ଜଣ ଲୋକ ଗୋଟେ ଜାଗାରେ ଥିଲେ, ଘଟଣା ତାଙ୍କ ସାମ୍ନାରେ ହେଲା, ଚାର୍ଜସିଟରେ ମଧ୍ୟ 6 ଜଣଙ୍କୁ ସାକ୍ଷୀ ହିସାବରେ ଦେଖାଗଲା, ପ୍ରସିକ୍ୟୁସନ ତା ଦେହରୁ 2ଟି ସାକ୍ଷୀଙ୍କୁ କଲା, ସେ 2ଟି ସାକ୍ଷୀ ହଉଛନ୍ତି PW3 ଆଉ PW6, ଆଉ 4 ଜଣଙ୍କୁ ପ୍ରସିକ୍ୟୁସନ ଏକ୍ସାମିନ କଲା ନାହିଁ। ତେଣୁ ସେ ଯୋଉ 4 ଜଣଙ୍କୁ ଏକ୍ସାମିନ କଲା ନାହିଁ, ପ୍ରସିକ୍ୟୁସନ ଯୋଉ ଏଇ ଯୋଉ 2ଟା ସାକ୍ଷୀଙ୍କୁ ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଡିସବିଲିଭ କରାଯିବ କି ତାର ନ କରାଗଲେ ମଧ୍ୟ ତାର କିଛି ଇମ୍ପାକ୍ଟ ରହିବ ନା, এই ବିଷୟରେ ଆପଣଙ୍କୁ ଆପଣ ପ୍ରଶ୍ନ ପଚାରୁଛୁ। What is the law? Have you gone through the section in the Evidence Act, section 134? What did that section say? Are you having that Evidence Act with you? Na ମୌଖିକ ଅଛି, ସବୁ ଜିନିଷ ମୁହଁରେ ଅଛି. So you are arguing a criminal appeal. Are you not supposed to have that criminal major acts with you? You are so confident that then pass on that Which section we referred?
134.
What it says?
Number of witnesses. No particular number of witnesses shall in any case be required for the proof of any fact.
What does it mean? Sorry to say, or rather we are sorry to say that this sort of performance is not expected from an additional assistant standing counsel, additional standing counsel. Are you aware that there is a settled principle of law that even if evidence of solitary witness can also be accepted, we said it on that day also. ଜଣେ ଗୋଟେ ସାକ୍ଷୀର ବୟାନ ଉପରେ ମଧ୍ୟ ଜଣକୁ ଦୋଷୀ ସାବ୍ୟସ୍ତ କରାଯାଇ ପାରିବ ଯଦି ତାର statement believable habo, truthful habo, above board habo, clear, present habo. एमती गोटे pronouncement अछि एटा जानिछन्ती तो? So it is not the quantity of evidence but the quality of evidence that counts. That is the law, right? So it is not expected of the prosecution to examine all the witnesses. Okay. So the selection of witnesses must be fair. Suppose at a particular place, there are some witnesses, let us say there are 5 to 10 witnesses, and the prosecution is choosing those persons who have hostility with the accused and or not examining the independent witnesses. They may say that, it may be say that they are making pick and choose and suppressing the thing. So, but when that is not the case, then co-villagers are there, 7 to 8 co-villagers are there. They are selecting 2 witnesses, examining them. And they are the father and son, and one of them is the injured. So his presence cannot be disputed at this spot. Right. So if the prosecution examine, so the contention which is raising, that merely because the other witnesses were present at this spot, not examined by the prosecution during trial. So can that be a ground to discard the evidence of P and 6? What is your? It cannot be. So now you are sure that is the proposition of it. So what is the next thing which we also said, that what importance is to be given to an injured witness? No. What type of, why in law importance has been given to an injured witness? Why? Suppose 3 to 4 witnesses are examined. One of them is an injured witness. Here also charge has been framed and he has also been found guilty. Right? 324. So what is the law that how the injured witness statement is to be assessed?
Because he is the best person to tell everything.
Why he is the best person? Why an injured is the best person?
He has seen all the things and he has also...
Because his presence at this spot at least cannot be disputed. That is one thing. But again, it is subject to the post scrutiny whether he merely because his present at the spot, that does not necessarily mean that he is a truthful witness. He may also say, also, his evidence is also to be assessed carefully, but it is an additional feature that his presence cannot be disputed. That is the law. So now let us cross over. Now the next submission he makes, that one of the eyewitness who is an injured has stated that how the appellant white, that is the evidence he has given, at a particular hand, right hand, beat me on my right hand by the teeth. He made a submission on that day that she was examined by the doctor, PW7, but the doctor has not noticed any such bite mark on the right hand. So, therefore, the version of this PW3 is doubtful. What is your submission?
But in para 2, my lord, PW7, evidence PW7, para 2, my lord. The doctor has carefully stated that on 8/6/2009, the IO of this case made a query and wanted to know if the injury of the forearms of injured Sanatan is possible by tooth bite. I replied to the query in affirmative, giving my opinion that injury number 1 is possible by human tooth bite. Exhibit 9 is a report and 9 is.
But was there any teeth mark in medical examination?
Medical.
Was there any teeth mark in the medical examination?
No definite.
When there is no definite, what is the report?
In cross-examination, he has stated.
No, there are only 2 marks. Abrasion on 2 over right forearm, abrasion upper part. Both the injuries were simple in nature and might have been caused by hard and blunt object within 24 hours. I replied to the query in affirmation, giving my opinion that injury number 1 is possible by human tooth bite. Why you are not reading it? It is very clear. It is there. So that is there.
That is also the Moody's jurisprudence.
Yes.
That abrasion
is possible.
So, the contention of the Learning Council that there was no corresponding injury cannot be accepted. That is your submission. Good. Now you come to the next one. It stated that the PW3 says that this appellant dealt a blow for which Madhav fell down. Right. Thereafter,
again Kirod dealt a blow.
Again Kirod dealt a blow and he lost his sons. So what she says about the 2 blows? 2 blows, right? So far as PW3. PW3 2 blows. So far as PW6 says that 1 blow was given, and no further blow. But in the cross-examination, he has stated that about 3 to 4. He said that it is a discrepancies in the evidence of both the witnesses, that whether it is 1 blow or 2 blows or number of blows. Since the doctor who has conducted post-mortem examination, he has perhaps noticed 3 injuries on the head, right? So that is one aspect. He says that it is somehow rather discrepant, and he stated that the witness who was stated in the chief examination like PW6, that one blow was given, if she has stated 3 to 4 blows were given by the deceased after he fell down, so he cannot be said to be a truthful witness. Chief examination में कोई गोटिए ब्लो मात्र appellant देइची माधव को ता मुंडरे तापरे से पड़ी गला बाकी जा assault हेची सेटा PW3 ऊपर हेची right एटा होची PW6 रो वर्जन किंतु क्रॉस एग्जामिनेशन ने कहूची जे से 3-4टा ब्लो देला प्रथम ब्लो देला बैक रे देला परे माधव पड़ी गला परे आउ जेतिको ब्लो से ताकू हेड ऊपर देइची. It is totally different from the examination in chief. कारण examination in chief रे गला गोटिए ब्लो देला मुंडरे पड़ी गला परे आउ किसी ब्लो दबा कथा chief examination ना. क्रॉस एग्जामिनेशन ने कहूची 3 to 4टा ब्लो देइची प्रथम ब्लो देला परे पड़ी गला तापरे आउ 3टा खंडे ब्लो देइची. So see, it is submission that is discrepancy, right? Then again, that is one point. So you are to answer it that whether these are the discrepancies which are to be.
Does it amount to discrepancy?
Does it amount to discrepancy?
The witness who speaks, who deposed at the time of giving statement, gives a different answer during the cross examination. Does it amount to discrepancy? Elaboration, how do you say this?
There is discrepancy.
Discrepancy.
There is discrepancy. In chief, he is telling that one blow, and in the procedure, he is telling 3 to 4 blows.
So whether that discrepancy, according to it, is discrepancy, whether it is fatal in nature and it affects the prosecution case or the evidentiary value of that particular witness. गोटे कथा आपण चीफ एग्जामिनेशन रे कहउचंती आ गोटे प्रकार कहउचंती क्रॉस एग्जामिनेशन रे एटा से विटनेस रो एविडेंशियरी वैल्यू पर किसी फरक पकउची कि जे ताकू कहा जाई परिबो कि एटा गोटे ट्रूथफुल विटनेस वैल्यू.
There is assault.
No, again we said on that day that we are not there. We are to go by the evidence because these PW3 and PW6 are the eyes and ears of this court. We are to assess their evidence. We are not present there on the occurrence request. Now your witness, who are our eyes and ears, have stated like this. So if it is discrepancy, what is the, according to you, that whether it is such fatal that it is to be totally discarded or something else is to be seen, that is to be accepted in spite of these minor discrepancies in this nature, or can say little exaggeration, little elaboration, whatever. Minor, according to you. Okay. So that, according to you, does this statement which he has given in the cross examination by PW6, in spite of that, there is no reason to disbelieve his evidence. That is your submission. Okay. Now you come to the that is the lodging of the first information requirement. So as it appears, the prosecution has stated that the scribe of the FIR is PW 5. Right? And we pointed out on that day that PW5 in the page number 48, he says that on 27 to 2009, he was requested by Sulabha Pradhan, right? The younger brother of the deceased, who is the Sulabha Pradhan, has been examined as PW1, right? So PW1 requested him to scribe the FIR, and accordingly he scribed the FIR as per the dictation, and that was read over, and he admitted to the contents to be true and signed on the same. What is his submission? That in this report, there is nothing mentioned that this report was scribed by PW5.
No endorsement is there.
Endorsement is there. किंबा obviously it नहीं जे पढ़ी सुने ये कली सेमती भी endorsement नहीं. That on the other hand, PW1 has just stated
that he got it scribed from a person who was in the shop in front of the police station.
Just come to that particular line. PW1 wrong, page 2.
When he was the shopkeeper.
PW1 wrong, page number. A gentleman of Gondia wrote the FIR as per my dictation, read over and the same to me on finding this one so. Hala. तापर से टिके इलाबोरेट करिकिनी से आणुचंती क्रॉस एग्जामिनेशन रे से एफआईआर टा कोठी लेखा हला से सेटा से कहउचंती if you come to page number 34 paragraph number 7 the last line tells the scribe of the FIR is a shopkeeper, right? Having his shop in front of Gondia police station on the date of registration of the case one. So, PW5 on the other hand is the sarpanch, right? And in the cross examination, he says, where was he when he was asked to scribe the FIR? That is in page number 48, paragraph number 5. Says that I met Sulava. Sulava means PW1, the informant. At Gondia in a motorcycle showroom where I was repairing my motorcycle. ତେଣୁ ସେଇଠି ତାର ଲେଖାଟା ହେଲା ତେଣୁ ଯୋଉ ଆପଣଙ୍କର ଇନଫର୍ମାଣ୍ଟ ସେ କହୁଛି ଯେ ପୋଲିସ ଷ୍ଟେସନ ସାମ୍ନାରେ ଗୋଟେ ଦୋକାନ ଥିଲା ଜଣେ ଭଦ୍ର ବ୍ୟକ୍ତିଙ୍କୁ ମୁଁ କହିଲି ଏତଲାଟିଏ ଲେଖିଦେବାକୁ ସେ ଏତଲାଟି ଲେଖିଦେଲେ ମତେ ପଢି ଶୁଣେଇଲେ ମୁଁ ସେଗୁଡା ନେଇକି ଥାନାରେ ଦେଲି ଆପଣ ଜଣକୁ ଆଣୁଛନ୍ତି ସାକ୍ଷୀ ଯିଏକି ହଉଛି ଏଫଆଇଆର ଲେଖକ ସେ କହୁଛି ମୁଁ ଗୋଟେ ମୋଟରସାଇକେଲ ଦୋକାନରେ ଥିଲି ଆଉ ସେଠି ମତେ ଇଏ ଆସି କହିଲା ଲେଖିବା ପାଇଁ ମୁଁ ଲେଖିଲି ଆଉ ଏଇଟା ହଉଛି ସେଇ ଏତଲା ତେଣୁ ଆପଣଙ୍କର ଦିଟା ଭର୍ସନ ଆସୁଛି ନା ନାଇଁ ଏଠି ଏଫଆଇଆର ଟା ଯୋଉ ଏ କେସରେ ଦିଆହେଇଛି ସେଇଟା କିଏ ଲେଖିଛି ଯୋଉ ଲୋକ ଯାହାର ଦୋକାନଟା ଗଣ୍ଡିଆ ଥାନାର ସାମ୍ନାରେ ସେ ଲୋକ ଲେଖିଛି ନା ଏ ସରପଞ୍ଚ ଯିଏ ସେ ମୋଟରସାଇକେଲ ଦୋକାନରେ ଥିଲା ସିଏ ଲେଖିଛି ତେଣୁ କୋଉଟା ଏଟା ଗୋଟେ ସେ ତାଙ୍କର ସବମିଶନ ହଉଛି ସେ ସସ୍ପିସିୟସ୍ ପିକ୍ଚର ତେଣୁ ହ୍ୱାଟ ଇଜ ୟୁର ରିପ୍ଲାଏ ଟୁ ଦ୍ୟାଟ୍
No, here the prudence demands that the person, the informant belong to Sorisia Pada, of which PW5 is the sarpanch. So it is expected that the person must know his sarpanch, know name of the sarpanch. So he could have named the sarpanch, or he could have at least said that I got it scribed from the sarpanch. Neither he knows that he is the person a sarpanch or his name, though he belongs to his village. So he is not taking the name of PW5. He is taking the name of a gentleman. He is not taking the name of anybody. So it is very specific that it is a shopkeeper. He is a shopkeeper. It is very specific. So how do you say that PW5 could be the scribe?
PW5 कौन है जे मोर गंडिया हमारे सामने
दुकान अछि
ना नो कौची ये सरपंच था ना तेणु तार सेठी दुकान नहीं तेणु ऑब्वियसली ये जहाटू लेखैची से लोक सरपंच नुहे मोटर ये जहाटू लेखैची गंडिया थाना सामना रे से सरपंच नुहे से आ गोटे लोक किंतु जो एतलाटा थाना रे दिया है सेटा को लेखिची सरपंच ताले इंटरप्रिटेशन होची जोटा ये गोटे प्रेजेंट थिला that has not seen the light of the day. जोटा
PW5 जोटा कହୁଛି
PW5
जोटा शॉपकीपर जोटा
शॉपकीपर जोटा लिखेइची सेटा आनिकिनी प्रेजेंट करची ताकू चिर देइचंती आपण तापरे एटा गुटे आ गुटे तला आपण देइछन सेटा काहे कि न हो
PW5 admittedly is a political man.
Political.
And the plea of the defense is that because of political rivalry, he has been implicated. A question has also been put to PW5 where he has admitted that the accused has not casted vote in his favor.
Paragraph 5 res pachari it is not a fact that due to political rivalry and for the reason that the accused and his family members had not rendered me support during the last election at the instance of so and so, I wrote the affair falsely implicating the accused with the occurrence. It is not a fact that I am in the habit of lodging false affairs against the political opponent. A suggestion be ଦେଇଛନ୍ତି ତେଣୁ କଥା ହଉଛି ଯେ ଇନସେପସନ ରୁ କେସ୍ ର ଇନସେପସନ ରୁ କିଛି डाउटफुल फीचर ମଧ୍ୟ ଆସୁଛି ଯେ ଏତଲାର ଯୋଉ ଲଜିଂ ଉପରେ କିଛି ଗୋଟେ डाउटफुल फीचर ଆସୁଛି ଯେ ଏତଲାଟା ମୁଁ ଯଦି ଗୋଟେ ଏତଲାଟା ଦେଇଛି ମୁଁ ଗୋଟେ ଲୋକଠୁ ଲେଖିକି ଦେଇଛି କହୁଛି ଭଦ୍ର ଲୋକ ସେ ଏତଲାଟା ଯଦି ଥାନାରେ ମୁଁ ଦେଇଛି ତାହେଲେ ସେ ଗଲା କୁଆଡେ ହେଲା
So in such an eventuality, what was the role of prosecution? What best could have been done? As you said, the statement of the witnesses are not fully truthful. All right. And there is discrepancy as far as the scribe of the affair is. So was it not required for the prosecution to examine other witnesses who were present at the time of incident, who have been withdrawn, to give corroboration to the statement of the witnesses? Here the importance of other witnesses comes. Because we do not find, or apparently as is being discussed, the statement of the witnesses are found to be not completely truthful, or at least PW5 is a different person. So this was a case that we have deliberately given to you to prepare yourself thoroughly. And this is the third day. Why do you agree with us? Whatever question we are posing to you, why do you agree with us? You disagree and find out the law. We have thoroughly discussed the thing now. What is the nature of affair? The statement of the witnesses, various discrepancies, if can be taken as discrepancies affecting the prosecution case, other witnesses were to be examined or not. These examination of the witnesses are sufficient to bring home the charges. Medical reports substantiate the statement of the witnesses. So you must have to be very assertive. Any question that is put to you should not be agreed. Yes.
Have you marked one thing further? He has of course not raised this point. You see this signature of the informant at page number 26. Right. This is the original affair which was marked. Now you see the page signature in the page number 28. Think that the person who signed this, made this signature is the same person. At least it appears differently. I don't know whether. Same thing. No, it is oh, it's a paper book they might have written it. Paper book is different. Yes,
LCR
LCR order. Oh, it is written now.
Nothing.
No. This paper book FIR.
Paper book is little different.
Paper book ta ହାତରେ ଲେଖିଛନ୍ତି ସେମାନେ ଏ ଯୋଉ ଏଚଏଲ ଟାକୁ ଆମର ରେଜିଷ୍ଟ୍ରି ହାତରେ ଲେଖିଛି. It's not the original one.
Here
The
is
Xerox is na.
Here is the signature and
এটা ଦେଖିଲେ
the statement right there.
এটা proof file ଆପଣ ସେ ଯୋଉଟା
That LCR statement right. It is not pro.
No. You do handwriting handwriting.
That is
এইটাକୁ ମୁଁ register
completely different. Yeah.
এটা ମୁଁ register ଲେଖିଛି. ବାକି ଗୁଡାକ ଜେରକ୍ସ କଲା ଏଇଟା ଯେହେତୁ
এটা পুরো অলগা.
এটা register ଲେଖିଛି. কারণ তার রিসিপ্ট ফিসিপ্ট এଠି ଅଛି ସେମାନେ ସେଟା
ଅଲଗା
ଲେଖିଛନ୍ତି.
ସବୁ
question ଥିଲା ଏଇଟା ବୋଧେ ଯଦି ଏ ପ୍ରଥମ ପେଜ ଏଗୁଡାକ ସବୁ ଅଛି ଇଏ ବୋଧେ ଲେଖିଛି ଏଇଟା ବି ବୋଧେ original ଏଠି ରହିଛି ନା
That's a good question.
good idea.
Nothing else or imposing. How could you submission करिवे?
May I submit one thing?
Yes.
Let have a glance. PW3 minor.
Yeah.
Para 6 minor.
Para
6 minor.
Cross examination.
Cross examination. The last line, my lord, I never met the Sarpanch after the occurrence. One Debraj Sahu is the proprietor of the shop situated near the spot. Cross examination, para 6/%. Cross examination, para 6, PW3 my lord.
Page number कितने?
41 my
41.
my lord.
The Sarpanch of the village
Was not present at the spot. I never met the Sarpanch after the occurrence. One Debraj Sahu is the proprietor of the shop situated near the spot. That was also stated by the informant that one shop was situated in front of the.
By way of this cross examination, you
have
mean
tried.
to say you are tried that one Deborah Sahu is actually the scribe of the FIR.
No, my lord. One shop was situated and that owner was Debraj Sahu as per the information of the informant.
But he has
the
not
shopkeeper
denied.
seated.
Near the shop,
But you have never
near the spot.
got that he denied to have right. PW3 has nowhere denied. PW3.
My lord.
PW3 speaks of it.
My lord.
How does
PW3.
whether he has met or not is not important.
No, my lord, that was the corroboration with PW1 informant stated that one shopkeeper is there in front of there. The scribe of the FIR is the shopkeeper, and the PW3 also stated that.
Madam, that shopkeeper, which shop is situated in front of the that police station, that is relevant. So
This is the corroboration, my lord. Regarding PW1 to
एटा
PW3.
spot
My lord.
spot ru Gondia police station ro distance ta formal FIR re देखुची it is 15 kilometers. Page 23.
My lord. So my humble submission before lordship, as per the PW3, he stated that Debraj Sahu is the proprietor of the shop, and the same was stated by the informant.
No.
Informant says Debraj Sahu name was not mentioned, my lord, but other things are there. That's why
He has not mentioned the name. He has not denied that PW5 is not the tribe. Has he denied? You have not brought any questions on that.
ये कहउचंती PW1 कहला जो scribe काहाटू कहला ना जो shopkeeper रो दुकान
the scribe of the FIR is a shopkeeper.
Yes.
Having his shop in front of Gondia police station.
हाँ एटा ये कहउची जे घटना जगह रे गोटे दुकान थिला
Debraj Sahu is the proprietor of the shop.
तार होची देखो ता संगे यार रिलेवेंसी कोन
सेटा एट द स्पॉट
एटा होची स्पॉट एटा होची जो जगह रे एफआईआर लिखा हला एफआईआर लिखा आइची गोंदिया पुलिस स्टेशन सामने रे जो दुकान से दुकान जरिया रे आउ एथी गोटे स्पॉट रे गोटे दुकान थिला जहार मालिक होची देवराज साहब.
Just before that, he was stated that the Sarpanch was of this village was not present at the spot.
Maybe Sarpanch has not said that I was present in this spot.
My lord.
PW5 has not stated that I was present in this spot. That is not the case.
Say you line ta mone karo I have not made the Sarpanch.
My lord.
এই জিনিস আপনি এক্সট্রাক্ট করেছেন PW1 to that would have been relevant.
Yes.
PW1 only stated that the FIR scriber of the FIR was the shopkeeper.
So indirectly you have brought that
shop in front of Gondia police station. 3 and 6 is not the reliable witnesses as because much more contradiction between both the witness minor. One PW3 stated that after the occurrence the deceased was senseless, but that same thing was not stated by the PW6.
That is not very relevant to that.
And another thing, my lord, 5 and 6 also stated have a glance on the 5 also not supported the seizure list, my lord. On para 5, my lord, MO does not contain my signature as a token of proof that it was seized in my presence. PW6 also stated that on para 7, I had not signed on MO at the time of seizure. I cannot say what was written on the seizure list on when I signed, my lord.
on para 7 PW 6 my lord.
ये लाइन टार इम्पोर्टेंस कौन अच्छी ये जो पेज नंबर 34 रे पैराग्राफ नंबर 7 लास्ट टू लाइन्स
I lodge affair.
हाँ
I lodge affair. When I lodged the affair, my brother was alive. Describer of the
ऐसे थी मार्क करूँ I lost the affair. When I lost the affair, my brother was alive. Now you come to the affair. आमे नहीं गाड़ी भड़ा करी ढेंकानाल डाक्तरखाना को नहीं गलु सेठारे डाक्तर बाबू देखाइबारु से मोर बड़ भाई माधव प्रधान मरी जाइछन्ती बोली कहिले तो ए जो एतलाटा दिया है एटा मरिबा परे दिया है ठीक ना नहीं तार भूल अछि गोटे एतला दिया है जेतेबेले ता भाई बंची थिला किंतु सेटा को कुआडे गला तार किछि पता गता नाही ए जो एतलाटी आपण देखुछन्ती एटा दिया है भाई मरी गला परे so does not it mean that real first information report has been suppressed vis-a-vis से जो statement से कहउछन्ती जो हमें आठु लेखेलु से एगुडा का कनेक्टिंग नेले
सरपंच कहला मु लिखि पेठी
दीटा जिंस देखंतु एतलाकारी कहला मु प्रथम जो रिपोर्टटा देली से रिपोर्टटा लेखेली काहाटू ना गंडिया पुलिस स्टेशन सामना रे गोटे दुकान थिला से दुकानी ठो लेखेली एवं पुणी कहूची मु सेतिकी बेले एतला देली जेतबेले मो भाई बंची थिला हला वर्तमान आपण गोटे साक्षी को एग्जामिन कले एज स्क्राइब ऑफ द एफआईआर जे होची सरपंच PW5 एवं सेही सरपंच रो एतला रे लिखाई छी जे सेतबेलु ता भाई मरी जाइथिला तेणु जो एतलाटा से दुकानी ठू भाई बंची थिला बेले लिखा आइथिला से एतलाटा को आपण सप्रेस करिसेंती एक कथा काहे कि हम धरिबानी what would be the effect of a real first information report is suppressed what would be its effect apanଙ୍କର entire case whether it is to be shrouded in mystery or it is to be held in doubt there is a decision of the division bench for political person Palgopal Pandar something 1990 Katak Law Times page 1 is it there Katak Law Times the cheating Mogil
sir I would achieve we are Supreme Court
हाँ सेटा भी लगता है
এটা আছে
सेटा से जो 1990 that was argued by I think Prabir Palid had argued that case and it is reported in 1990 CIT page 1 each of them was CIT page 1
I would copy
Gopal I think it's a Balangir case এটি মারলে এটা খুললে প্লিজ bit monocultural. Well, yeah. While elaborate for each position. This is most important line. In the consideration, paragraph 12, in consideration of the aforesaid facts and evidence, we do not hesitate to hold that the two first information reports submitted by PW1 with the informant was suppressed by the prosecution. Had it been treated as FIR and produced during trial, the story narrated in it would have been unfavorable to the prosecution. Therefore, while it was managed that it would not see the light of the day, a first information report which suited the prosecution but not revealing the true incident was brought into being. In such circumstances, it would be reasonable to infer that the first information report contained a tainted, embellished, and exaggerated story, but not a true one. Here, this case, everything was consistent. Eyewitness पूरा version ये नथिला, medical evidence corroborate थिला, ସବୁ थिला. ସେଇ point ଟାକୁ ଧରିଲେ ସିଏ ଯେ ଆପଣ ଯଦି once ସେଇଟାକୁ manage କରିଦେଲେ ତାପରେ ତ ସବୁ ଚାଲି ଆସିବ. FIR ଟାକୁ ଯଦି ଗୋଟେ FIR ଟାକୁ ଆପଣ ଚାପି ଦେଲେ, ଗୋଟେ version initial version ଟାକୁ ଚାପି ଦେଇ ଗୋଟେ present କରିଦେଲେ ନୂଆ version, ତାପରେ ଆପଣ story ଗଢି ଚାଲିବେ, witness consistent ଆସିବ, ସବୁ ଆସିବ. ତେଣୁ ଏଠି ଏଇ ଯଦି analogy ନିଆଯାଇଥାଏ, ଯଦି ଯୋଉ report ଟା PW1 से दुकानी ठू जहार दुकान टा होची थाना सामनारे से रिपोर्ट टा को जेतेबेले ता भाई बंची थिला से जो रिपोर्ट टा दिया गला से रिपोर्ट टा जदी वर्तमान रेकॉर्ड को आसी थांता जोटा की आसी नाही बेली जदी इन्फॉर्म हुए ताले सेट दैट वुड हैव बीन द इनिशियल स्टोरी द ओरिजिनल स्टोरी ऑफ द प्रोसेस so that was managed to जदी होल्ड करा गला एवं गोटे रिपोर्ट आसिला को रिपोर्ट को आपण ट्रीट कले एफआईआर जो रिपोर्ट दिया हेची ता भाई मरी गला परे एवं that was written by PW5. So two things are there. So one report which has been lost by PW1 while his brother was alive, and that was scribed by a person or a shopkeeper whose house, whose shop is situated in front of the police station. So that is not seeing, we are not seeing the light of the day. So had it been treated, had that report has been treated as FIR, then the story of the prosecution would have been different. So this is language. Had it been treated as FIR and produced during trial, the story narrated in would have been unfavorable to the prosecution. We to आपण अलगा कोन version ଦେଇथिबे सेतळे प्रथम version टा आपण सेति पई आपण ताकू चापी देले एवं गोटे एतला सृष्टि कले कहा द्वारा ना गोटे पॉलिटिकल लोक जियाकू सजेशन ऑफ कोर्ट दिया जे डिफेंस मध्ये एग्जामिन करछि accused wife मध्ये एग्जामिन हेछि as a DW1 से मध्ये से पॉलिटिकल हॉस्टिलिटी कथा कहउछि एवं ताकू भोग दिया नथला बोली ताको भीतर शत्रुता थिला एवं सेथि पई सेई ता द्वारा जो लिखित एतलाटा को प्रेजेंट कराइछि कोर्ट रे जो थ्रू की येटा हेछि.
And what is the relationship between PW3 and 6 in say?
Son, father and son.
Who is PW3?
PW3
Sanatan Behra and Pavitra Behra.
PW3 is the father, na?
PW3 is the father.
Father and injure.
And PW1 and 2 are brothers.
Two brothers.
2 has not supported.
Supported. Supported.
I was at home and got information about the assault in part 2.
PW2 my lord, para 5 evidence. You have stated that at that time, though my brother was alive, not responding to our call.
volume 7. 1990 volume 7.
The conflict between medical evidence will achieve. Evidence of eyewitness is not reliable. So if were watching that is when you can virgin in the mouth of the eyewitness reporting consistent to that. Here you see accepted the prepared report for the investigating the correct the two cases would have been confronted justice done, but for the reasons one so as you suspected different color was given to the offense and see light to someone and many trial account. Like we see a good CCD someone and that is the right way. And if they have a lot of marriage in them, doesn't have another year to be. No, just a little bit like a other suggestion or that. So we are reserving this how the council to the appellant now and Mr. Pradhan. Mr. Sarath Pradhan, learning additional standing council. Giving his school judgment.
So today I submit one judgment, my lord, credibility of the witness
Given.
wholly unreliable. Presence of accused also in doubt.
That's a blood stain napkin would